morning, everybody. Happy St. Patty's Day, March 17th, despite what the thumbnail says. Thank you, Ashley, for pointing that out. I'll fix that momentarily. Welcome to TCF Live. My name is Dan Soul. I'll be your guide on this journey for the next 4 hours. Let's get our day started with Judge Middleton.
And I'll get in the old days, when I had a stenographic court reporter, I would do things in my office and he would write it. And even once or twice we did it outdoors under a tree, but you can't do that in the freezing weather, and you can't do it when you've got all electronic equipment. Anyway, Miss Sanchez Wilson, you got charged with drunk driving, operating while intoxicated. In Michigan, that's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. It carries 6 points on your driving record, and it requires that your driver's license be suspended. This happened allegedly at Railroad Drive and Michigan Avenue. We got a lot of arrests right in that spot.
All right, we're going to hit pause just a moment and start this over. Good morning, everybody. Happy Tuesday. Welcome to TCF Live. My name is Dan Soul. I'll be your guide for the next 4 hours, and we'll get it right. So sometimes what happens, a little behind the scenes here, is I have a Stream Deck to control things, but sometimes when you boot stuff up, those switches can get flipped, and what you think is off is on, and what you think is on is off. And that's what happened there. So apologies. Let's go back to Judge. We'll get it right. Sometimes a Tuesday has just got to do a Monday for you, but we'll just keep moving.
License is also expired. How old are you, Miss Wilson?
About 21.
You owe $1,629 worth of unpaid fines and costs since 2024. I just can't figure out, as young as you are, how you manage to get in so much trouble. And now you've got this. Are you still living? Are you at Cato or are you on A.L. Jones Road?
A.L. Jones Road.
All right, your driver's license is expired and it shows you live at Cato Lane. Any mail they send from the Secretary of State goes to the address on your driver's license.
Yeah, I haven't been able to go and change it yet.
And they don't forward it.
Yeah.
So, all right. Well, anyway, my advice is we get a lawyer to help you with this.
Yeah.
Are you working somewhere?
I start today. I'm supposed to be there now, but they told me just come after.
Where's that?
Myers Distribution Center in Middlebury.
All right. Well, you don't have a valid driver's license right now because it's expired. How are you going to get back and forth to work?
My boyfriend takes me.
All right. Show a plea of not guilty. I'm going to set an attorney pre-trial. I'm going to set it all the way out for May 1st because Mr. George doesn't want to be here on March 27th. So we're going to bump this out a ways. He doesn't want to be here on April 3rd either because we're not open. So I'm going to set attorney pretrial May 1st, 2026. we're probably gonna move the Liberty Bell ceremony to the 30th. Friday morning is such a dense, heavy morning that I think we'll do the Liberty Bell on May 30th, and we should probably be on the other side by then. Anyway, Miss Wilson, Sanchez Wilson, I want you to start paying on your fines.
Yeah.
And I want you to stop driving until you get your license. Your license right now is expired. It's not yet suspended from this drunk driving charge.
Okay.
In the old days, they used to suspend you for unpaid tickets. A lot of these are driving tickets, no insurance, no operator's license, leaving the scene of a property damage accident, no valid license. They don't do that anymore. So if you go to the Secretary of State and renew your license, you probably will be valid pending a disposition of this drinking driving charge. So A, they need to know where you live. You don't live in Sturgis anymore.
Yeah.
B, you need to renew it, and then I think you'll be valid till this other stuff hits.
All right.
One way for me to wipe out all those fines is to put you in jail, to give you about 1,000 days in jail and wipe out all your fines. Not that much, but you've been blowing those off for 2 years. And I want you to start to make payments on them.
Okay.
All right. I'm going to send you out for an attorney May 1st at 8:30. I'll say set up payment plan. Kind of plan where somebody actually makes a payment. All right, you're good to go. But a lot of people that didn't show up. Carson Hardwick.
Yes, sir.
Could you come forward, please? Good morning, sir.
Good morning.
Yeah, thanks. All right, are you Carson Hardwick?
Yes, sir.
File number here is 263780N. You got charged under White Pigeon ordinance with being a disorderly person. I got an email late yesterday from the White Pigeon Village attorney. He said there's nowhere to go with this, but I would recommend fine and costs only, which would be $200 total. Let's look at your ticket. Allegation is that at 2:12 in the morning, there's one sign, on March 1st, that you were a disorderly person. And they lodged you and gave you a PR bond. Did you spend a night in jail?
Yes, sir.
All right, well, he's recommending no further jail and fines only. Under White Pigeon ordinance, disorderly person is a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $500. How do you plead to that charge?
I'm going to plead guilty because I want this taken
Well,
care
let
of.
me ask you something. Did anybody threaten you to get you to plead to this? Or promise you anything other than it would be
I-
fines and costs?
If I have to plead guilty to just pay a fine, then I'm going to plead guilty.
All right, were you drinking?
Yes, sir.
Well, what were you doing out in the 2 o'clock in the morning on March 1st?
I was I walked to the store to get another beer, and now I realized that was a bad choice.
Well, there's no crime in that, but it's 2 o'clock in the morning. You can't sell beer after 2 o'clock in the morning. So did you get into it with a clerk or something at the store? Did you get into?
I was there before I bought the beer.
Okay,
I had the beer.
all right, but you were drunk there at the store?
Yes.
All right, that'll probably do it. What do you do, sir?
I work construction. I do siding, entry doors and windows. I work I got a few places I subcontract through. So I work through 1-800-HANSON's, Top Home Improvement, and All Weather Seal. Right now I do mostly windows. Once it warms up a little bit though, I'll be slinging some siding.
All right. So you subcontract for some of the big companies
Yes, sir.
all over Southwest Michigan?
Over the tri-state area, yes. We work for Sir Home Improvement for my grandpa worked there for 35 years. So that's how I got into this.
All right, well, this wasn't the greatest, but I'm gonna follow their recommendation. I'm gonna give you 1 day in jail credit, 1 day. You did file with me your advice of rights, giving up your right to have a trial. March 1st was a Saturday night into Sunday morning. So that might make sense.
Just to clarify, that last advice rights was the previous.
Oh, and this will bring this matter to a close.
Can I pay that with a card today?
Sure. Under White Pigeon ordinance, that is 77000. Fine is $75. There's a $75 crime victims' rights fee, and a $50 state minimum fee. That's $125 of costs. If you're gonna pay that now with a card, we'll just call it good. 1 day jail credit, 1 day. So you woke up in the jail, somebody come pick you up.
I walked home
You walk from there.
to White Pigeon.
Yee.
I actually used to run about 6 miles a day. I'm from the Upper Peninsula originally, so I used to actually run to school.
I had to walk to school my whole career. It was 1 block from my house.
I ran a 4.8 40-yard dash.
That's pretty good. I ran a 503 mile, 504 when I was about 30. And I ran a 39:45 10K, but I was much younger. I wasn't so fat. All right, you go out to the counter, you can pay this fine. This matter's over and done with.
Yes, sir.
Next time, just stay home.
There will never be a next time, and I apologize for.
All right, good luck to you, sir. This is construction season. People are gonna start to get busy. Now, I got people that are here that aren't on my list, but Curtis Williams is here. Would you come forward? Good morning, sir.
All right, good morning once again, everybody. It's TCF Live. It's Tuesday. It's good to have you all here. Bear with me for a second. So earlier we had an audio glitch, and I need to cycle through my feeds to fix said audio glitch. So hang tight. We're going to flip through a bunch of feeds here real fast while I reset the audio. So That does that. That one's already reset. That one. That one. That one. Okay. Yay, I think we're good now. All right, we're going to, now that that's done, thank you for bearing with me just a moment. Let's go and say good morning to Judge McNally.
You have Mr. Zolnik's down there somewhere.
Does it?
Mr. Zolnik here. Your name, ma'am? You charged with fair to pay $213. Do you have the money?
No,
Where is it?
well, I just got a job. Yes.
Why didn't you come and talk to us? This was back in November. How much do you have today?
Like 100,
100?
100 and some odd shillings, yeah.
You gotta come and talk to us when you don't have the money, okay? You pay $100 today. How long will it take you to get the rest?
Before the end of the month, I said,
Just say by April the 6th, okay? If you need more time, call the court. We'll go on Zoom. I'll give you an extension, all right? Best of luck. People against Angel Police. Find out which one, Mr. Tim. Oh,
Simpson. Oh, we don't know.
26W 841592. Your name, sir? How you doing today? All right, you're gonna plead to impeding traffic, right? Is that what you're gonna do? You're gonna plead to impeding traffic?
Yeah.
That's 0 points, okay? So there's no injuries, minor damage to that charge. Responsible or not responsible? To impeding traffic. No, do you plead responsible? Do you admit that you were impeding traffic? No? You don't? That's okay. I'll start again. So they charged you with improper lane use causing an accident. You know that, right?
Yeah, but.
Wait, slow down. Now they wrote this up where you're gonna plead to impeding traffic, which is 0 points. It won't go on your record. You want to plead to that?
Yeah.
To that charge of impeding traffic? Do you plead responsible?
Well, they happened, I don't want those points.
All right, I'll accept the plea. 195 is your total. Okay, you can go down the hall and pay that and you're all set. Best of luck.
All the way down.
Yes, you're into the hall. Thank you. I'm gonna need Beth on this.
Timmons.
Yeah. People against Heather Timmons, Heather Marie Timmons, 4T642857A. Do I have an appearance from you, Mr. Zelnick?
You should, because they adjourned the previous hearing because I was out of the country.
Okay, Heather, can you tell me, just make sure that we do?
Judge, I do. It's up here on my desk.
Okay, good enough. Your appearance?
Never tell an act for the defendant, and please give your name.
Heather Simmons.
All right, so I've called in probation. They'll be here momentarily. I have a show cause that she pled not guilty to, or I entered a not guilty plea to failure to refrain from violating a law, being convicted of drug paraphernalia possession through the 27th on December 10th. And then I have another one here that alleges she failed to refrain from consuming alcohol or drugs, testing positive for alcohol on March the 9th. And she indicated in a form, she admitted that she consumed alcohol or drank a pint of vodka on March 5th, 6th, 7th, and 8th. So I have two show causes here, two different ones. So this one is dated March the 10th. And that is the use of alcohol. So she never showed up on the March the 3rd, it looks like, right?
They adjourned that date.
Okay, well, let me just check something here.
And in the interim, we've got to replace the mental health board copy and one. That's the intervening factor.
Heather. Did
Yes,
Mr.
Judge.
Zelnick file his appearance before or after March 3rd?
I believe it was, let me look, Judge, because there was a little confusion on when I got it.
That's fine.
Um,
If you,
It was, I believe, right around that date.
okay. So good enough. I don't know what happened, but she wasn't here March 3rd and I did issue a bench warrant, but maybe that crossed with your,
Judge, I have it
Yes.
right here. It was March 2nd we put it in.
okay, so no problem. So I've got two show causes to deal with. One is the show cause of January 20, for failure to refrain from violating the law, and the additional one is from the show cause of March the 10th for failure to refrain from consuming alcohol. So how is she going to proceed on these?
Your Honor, she's going to enter a plea to both probation violations, and I have been in correspondence with your probation department indicating that she's been accepted into the mental health court in Wyandotte in her sentence. It was April 8th. We asked the court to consider postponing sentence until she's admitted into the program, unless probation has a better idea today.
Ms. Wilds, your name?
Elizabeth Wasserich, Your Honor.
Do you want to plead guilty to these charges, ma'am?
Yes.
If you plead guilty to the charge of violating the law, being convicted of drug paraphernalia, that is a non-technical violation. You could have your probation revoked and you could get 93 days on that. If you plead on the no alcohol charge, then you could get, since you have one prior technical violation, you could get 10 days on that. Do you understand that?
Yes.
You're presumed innocent. You have the right to a hearing. With a hearing, you have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights on the advice of rights that I just covered with you, and there will be no hearing. Do you understand that?
Yeah.
All right. Any questions before I ask you how you plead? All right, to the charge. That you were convicted of possession of drug paraphernalia out of Wyandotte on December 10 of 25. How do you plead?
Yes.
Were you convicted of drug paraphernalia on December 10 of 25?
Yes.
And you were on probation to this court when that offense occurred, correct?
Yes.
And to the charge that you consumed alcohol and were positive for alcohol at DNA on March the 9th, how do you plead?
Yes.
Did you consume alcohol, say, within the 3 days preceding that?
3 days prior, you could see alcohol within 3 days prior to taking the test. Close to that.
It was close, yeah.
All right. Anybody force you to plead guilty?
Yeah.
All right, give me 1 second here. There's all kinds of paperwork. All right, I'll accept your plea. Failure to refrain from consuming alcohol, testing positive March the 9th. I'll accept your plea to possession of to violating a law, being convicted of possession of drug paraphernalia out of Wyandotte on December 10th of 25. All right, give me a second here. All right. Anything that you would like to say?
Your Honor, I haven't heard what the current probation recommendation is, but I believe they welcome her admission into the treatment court, mental health court in 27th District Court. And if you're going to impose any more serious sanctions, we'd ask the court to pass on that date that you're intending for admission.
The only problem is here, we're coming to the end. I can't really send her to the mental health treatment court.
No, she's in there already. She, on the drug charge and we got her admitted into the.
No, I get it, but I'm not gonna,
Or assess penalties today, but I'd ask you not to look for incarceration, perhaps other punishment, because she's going in. That program, she's done very well meeting with the group already, and I think this is clearly over other issues been over the years leading to this collapse. There's a serious mental health issue.
no, I believe you, but the problem is I'm coming to the, well, I mean, I guess I've got until I sentenced her on November 7th, so I have until November 7th of this year. But I'm not excited about her violations. What did she do and not do, Ms. Wiles?
Yes, the violations that you see are the outstanding, issues. Ms. Timmons was actually fairly compliant on probation. We did have a violation prior for alcohol consumption. After that, she did really well. She's engaged in treatment at the guidance center. Outside of this testing and this conviction, she was, sober on her testing. The admit form from March 9th, my concern is what she admitted to was drinking on the 5th of March, the 6th of March, the 7th of March, and the 8th of March, a pint of
Each day.
alcohol each day.
Right.
So I'm very concerned, and obviously mental health court is a great positive thing. But I was gonna bring up, we are limited if anything would run concurrent over there or at the same time. Ms. Timmons does show for her appointments, she communicates well with me. But I think she has a severe alcohol problem that again, may be co-occurring with.
What about relapse prevention? What about something like that?
She's engaged in actual treatment right now at the guidance center.
Okay.
Yeah, with Alex.
How often is she testing right now?
At this point, we had her on, weekly, Your Honor, I think from her last violation, and I think I bumped her down. I want to make sure that we have her on, I think, monthly at this point in time.
Have her what?
On monthly at this point in time. She complied, we reduced her, she was weekly down to twice monthly and then down to monthly at this point.
How often is she testing in,
All day test on my.
my dots?
They haven't told me yet. I would assume it would be after my sentencing.
Is she on a sober link or anything?
No, Your Honor. Judge, clearly monthly doesn't work when
Right, I know.
slam a pint down.
Oh,
No, you're being upfront, you admitted it, and there's no correlating to what happened, I suggest you say nothing else. Because you can't, no matter what the pain is of the rest of your life, you can't bring to assuage the pain.
Where does she work at?
sure.
Where do you work?
I'm unemployed, right? I'm on SSI.
So. This troubles me. What kind of drug paraphernalia was it?
It was a.
Well, she,
I roll it at last. Without prescription.
No, I have to.
Why, you didn't have it prescribed too, it was
Right.
not in the box. It's a minor case, I believe they're taking it under the public health code, Your Honor. But irrespective of that, she pled guilty before I represented her. And all the pieces together.
All right, here's what we're doing. I'm gonna go light on the cost. I'm gonna charge you $25, which are to test bi-weekly going forward. You're to serve 1 day on the court work program, and you're to pay $35 for that. You're to serve 8 hours of community service by April the 30th. You're to be on a sober link by the end of the day for 60 days. You're gonna have to pay for it. You listen to me very carefully. I just assessed costs that were very, very, very nominal because I understand, but either that or I'm gonna have to send you to jail today. You don't want that, right? Sober link for 60 days by end of day, 8 hours community service by April 30. Continue your treatment at the guidance center. Test bi-weekly, serve 1 day on the court work program, and pay $35 for that. Did I miss anything?
Nothing, Your Honor.
Nothing, Your Honor.
All right.
Just understand the price of sober links could end up being a lot cheaper than.
I gotta make sure, one thing, Miss Wilds, when is her probation supposed to be up? I gave her 18 months.
7/26 is what I have for 18 months from the November date of 24 sentence.
I'll let it go at that, but any more violations, you have a big problem with me. I don't care when you pay the $25. You can set that up with her, okay? Thank you. Good
Thank you,
luck.
Your Honor.
Thank you. Ma'am, no more of this, please. No more, please. Thank you. Thank you.
It's TCF Live on St. Patrick's Day. Good to have you all here. I hope you're enjoying your day so far. I am, at least now that we've gotten past our slightly rough start, but such is life. If there's ever any question as to whether or not this is a human-run channel, all you need to do is look at all the errors. Let's continue with Judge McNally for a little bit longer.
Plead to impeding, right? Responsible or not responsible? Please accepted. 150 is your total. Cash your end of the hall to your right, okay? Have a good day. Now, listen, everybody. I'm gonna call one person up to the podium, and I'm gonna have some of you sit at the table here. Corey Allen Grimes Jr. up to the podium, 26B150050. I'd like Deborah Roberts and Lane Hayner and Amelia Moore seated at these tables, my right, your left. Come on up to the podium. Mr. Grimes, your name?
Court records.
All right, you're going to plead to impeding traffic, true?
Responsible, yeah.
To that charge, responsible or not responsible?
Responsible.
Please accepted. 160 is your total. You have an entry on here. You can go down the hall and take care of that. You're all set. Good luck. Deborah Sue Roberts, 26B150421. Your name, ma'am?
Deborah C. Roberts.
All right, so you're gonna plead to distracted driving, true?
Correct.
Responsible or not responsible to this?
Sir. Yeah.
Please accepted.
Set to go?
No.
Oh, I'm sorry.
You said you needed a payment plan.
Oh, yes.
How much do you have today?
I have nothing today.
How- Are you working?
No, I am not. I'm currently on disability
When can you pay this?
on the third.
Okay, all of it?
Half of it. And then the other half on the next third.
75 due by April 3rd. Balance by May the 3rd, okay?
Yes.
If you need more time, call the court. We'll go on Zoom. I'll give you an extension, okay?
Thank you very much.
You're welcome. Good luck. Lane Matthew Hayner, 26B150075. Your name?
Lane Hayner.
All right, you're gonna plead to impeding. Caused an accident, right?
Yes.
To that charge of impeding, responsible or not responsible?
Responsible.
There's no injuries, minor damage. You got one other entry on here. Your total's 205. You can go down the hall and take care of that. Please be careful, okay?
Will do.
Amelia Moore,
Yes.
26W841391. All right, so you're going to plead to impeding, right?
Yes.
Responsible or not responsible?
Responsible.
Please accepted. Just check here. All right, you gotta be careful. Your insurance company's gonna love you. Huh? Slow. Fines and costs are 155. When can you pay this?
Last 60 days, can I pay half April 10th and then the other half the next week?
Pay 75 by April the 10th, balance by May the 10th. If you need more time, call the court. We'll give you an extent. I'll give you an extension. We'll go on Zoom together, okay?
Okay, thank you.
Best of luck. Carolina, Michael, Red.
All right, friends, let's change it up a little bit. Let's head over to Romulus, Judge Oakley.
Gamber on behalf of Mr. Maddox, P 78192. He's also present with him. Going that.
Did we pick a date for this final pre-trial?
Kevin.
Council, pick a Tuesday.
Whatever, of course, convenient.
Any Tuesday. Mr. Lecky and the court will be here every Tuesday for the foreseeable future.
14th?
What time are you gonna do it, Heather?
14, we can do 8:45, 9:15. Whatever's good. It'll be on Zoom with Judge Patton.
Okay, 8:45 is fine.
And this is a final pretrial.
Yeah, complainant two up here. All right, I will continue bond. Yeah, it's working.
I hope you.
On this or something new?
This is, he was never arranged.
Oh, this one even never rang?
He comes from your thing.
Yeah, but I don't have files for new ones.
No. I'm just
He's just never been arraigned on this?
the issue that.
Yeah, I know.
Because you failed to.
How did we get to this point with no arraignment? Okay,
And one, just to clarify, he found out that he missed the day that he found out that he missed the day, we walked him in, downstairs. And he paid $150 on it, I think, and they withdrew the bench warrant.
Right. but he's never been arraigned. Would you waive formal reading?
Yes.
I'll enter not guilty on this file. All right, are we still asking for no contact, Mr. Lecky? Any problems with a no contact?
Nobody.
All right, so let's be clear. No contact of any kind, no social media, no phone calls, don't send letters, don't have friends go check. Issue?
They share a child, Your Honor, and they communicate on close, so.
So are we okay with, is it a front of the court situation or not?
Yes.
No contact.
Outside of the front of the court order. Is that clear enough? Okay, even if she calls and wants to get together. All right, so that'll take care of this file. Anything else on this file? Hold on. Mr. Maddox, you're into us for $601 on other files. Looks like you got a payment plan back to October. Are you current?
When I came in last time, I made a payment, and I believe they said I owe a payment in 2 days, which I'm gonna go downstairs.
Okay, all right. But we don't have files on the new stuff. We can't. Can I arraign him right now?
No.
Okay. I just left the cash as it is. Yeah. Yeah. I just added the no contact except for FOC. We'll get a notice for you.
Have a good St. Patrick's Day. Thank you.
Thank you, counsel.
See you right here. Really appreciate it.
Just sit down anywhere, Mr. Maddox. We're gonna get you a piece of paper.
Okay.
Alexandra Show, NDS.
Oh, I don't know which one she's on. Let me go over with Mary Ann.
Okay, just sent it.
Judge, I gotta tell you, how many times I need a new client that say, hey, I watch a lot of those court things on TV. Do you know, he's my favorite. I'm like, yeah. He said, you could have another career. I'm like, who's gonna pay me?
All right, friends, well, they're between things. Let's do this. Let's make our every morning trip down to Florida to see Wade Mercer for a few minutes.
Hear you, sir. I think you're muted, Mr. Ricardo. You're muted.
Thank you, Your Honor. Buenos días, señor Padilla. Yo soy Jordani Ricardo, intérprete para que se pueda comunicar con el juez. ¿Usted me ve y me escucha bien?
Sí.
He can hear me and see me, Your Honor.
Thank you, Mr. Padilla Martinez. You're here because you've been accused of one count of failure to appear for the charge of driving with no valid driver's license.
Señor Padilla Martínez, usted está aquí porque tiene un cargo de no haber comparecido por el cargo de no tener licencia de conducir válida.
I'm appointing the public defender's office to represent you and asking that you listen to your attorney, Mr. McDaniel.
Le voy a asignar la oficina del abogado de oficio para que lo represente y le pido que escuche a su abogado, el señor McDaniel.
Your Honor, I spoke to Mr. Martinez. He's going to enter a plea of no contest. The charge is listed. You understanding he'll be sentenced to 30 days in jail. He'll have 21 days jail credit, the $400 fine, which will be a civil judgment.
That was 21 days credit.
Correct.
Su señoría, él se va a declarar, no me opongo, yo he hablado con él. Él entiende que se le va a condenar a 30 días en la cárcel con crédito por 21 días, que tendrá una multa de $400 como un fallo civil.
Waives his right to a jury trial and call witnesses and understands that any plea can result in deportation.
Él está renunciando a un juicio con un jurado a llamar a testigos y entiende que cualquier acuerdo puede, en un caso penal, puede resultar en la deportación.
He understands that the Immigration Service has placed a detainer on him when he finishes up this sentence.
Él entiende que el Departamento de Inmigración de Estados Unidos tiene una orden de retención para él una vez que haya terminado con esta sentencia.
Thank you, Mr. Mitchell's at agreement with the state.
It is, Your Honor.
Gracias. Y señor Mitchell, ¿está de acuerdo el Estado? Lo está, su señoría.
Padilla Martinez, did you hear that agreement, sir?
Señor Padilla Martínez, ¿escuchó usted el acuerdo?
Sí.
Yes.
Is that the plea you would like to enter, sir?
¿Ese es el acuerdo que desea aceptar, señor?
Sí.
Yes.
I'm going to accept your plea of no contest to the charge of no valid driver's license.
Acepto su declaración de no me opongo ante el cargo de no tener licencia de conducir válida.
The judge will guilty of that offense and sentence you to 30 days in the Jackson County Jail.
Lo condeno culpable del delito y lo condeno a 30 días en la cárcel del condado Jackson.
You have credit for 21 days you've already served.
Tiene crédito por 21 días que ya ha cumplido.
And I'm imposing the standard fine of $400, which is under pursuant to state and county law.
Le voy a poner la multa mínima de $400 o la multa estándar que va de acuerdo con las leyes del condado y estatales.
Sir, our jail may actually let you go a few days early, so you may actually finish this sentence when you're in immigration custody.
Y señor, quizás la cárcel lo deje salir unos días antes, así que tal vez termine concluyendo esta sentencia bajo la custodia de inmigración.
Do you have any questions?
¿Tiene alguna pregunta?
No, sir. Está bien.
No, it's fine.
Have a good day, sir.
Que tenga buen día, señor.
Thank you, Mr. Ricardo.
Thank you, Your Honor.
We have Colton Gowans or Gowans. Good morning, sir. You're here for first appearance accused of one count of fleeing and eluding a law enforcement officer, one count of resisting an officer without violence. You also have holds for Washington County for the same charge, or perhaps other charges too. I know you've got a fleeing and eluding over there. You also have a detainer from out of state. I think it was the state of Kentucky. But what I'm first appearing you on is the local charges in Jackson County. I'm going to appoint the public defender's office to represent you. I have read the complaint. I've also read the Washington County complaint. So I noticed the striking similarities in the charges as well as the involvement of pit bulls in both cases. I am appointing the public defender's office to represent you. I'm about to set you a bond, but I'm going to listen to the attorneys before I do so. Mr. McDaniel, anything?
No, Your Honor.
And Mr. Mitchell?
Nothing for the state, Your Honor.
Sir, your bond's gonna be $25,000 on the fleeing and eluding, $5,000 on resisting. Your total bond in Jackson County, Florida is $30,000. You have a condition. Actually, there are no special conditions in your case. It's just regular bond conditions. You do have the hold for Washington and the out of state. Now, the out of state one's not on the jail list, but there is a detainer or a warrant in your packet. So Corporal, are y'all showing a detainer from out of state or a hold?
Yes, sir. Kentucky. We didn't bring him up for fugitive from justice.
Thank you, Corporal. I just wanted you to be aware of it, Mr. Goins, that I didn't want you to think you post bond here in Washington, you'll be released. You do have a warrant. You are wanted in another state. You do have the right to use the phone, though, for purposes of trying to post the bond. If you post the bond, you'll be released. If you're not able to post the bond, you'll be seen on the court date I'm about to give you, and the public defender's officer will be in contact with you April 7th.
Yes,
April 7th at 8:30 will be your court date. Do you have any questions, sir?
No, sir.
All right, have a good day. So I said 30,000. Next, we have Christopher Sawyer. Mr. Sawyer, good morning. Mr. Sawyer, you're here because you've been accused of one count of criminal mischief over $100 and one count of burglary of a unoccupied structure. Mr. Sawyer, there is probable cause for these charges. I'm going to appoint the public defender's officer to represent you and ask that you listen to Mr. McDaniel, your attorney.
Just ask for a reasonable bond, Your Honor.
Mr. McDaniel, my notes are very little history, but may be appropriate for a cash bond because there's allegedly some restitution owed. What's Mr. Sawyer's position on cash versus surety? I don't think so.
Cash, Your Honor.
Not that I know of. Mr. Mitchell, any objection to that?
No objection to a cash bond.
Mr. Sawyer, I'm going to set your bond at $500 cash on the felony, $2,500 on the criminal mischief. Your total bond is $750 cash. You'll get to use the phone in just a few minutes. If you post the bond, you'll be released. Hang on just a second. I missed something.
That's great.
The jail sheet says greater than 100. It doesn't become a felony, so it gets to 1,000.
It's greater than 1,000. Yeah, it's greater than 1,000.
Oh, it's missing a zero.
Okay, so the jail sheet's incorrect, and I remember reading that now. They allege some mirror and some robot vacuum cleaner, and added together, they are over $1,000. So I'm still gonna keep that same bond, but technically you're accused of two felonies. The criminal mischief felony will be $250 cash. The burglary charge will be $500 cash, so it's $750 cash bond. You do have a condition of no contact with the alleged victim or that property. Mr. Sawyer, you will get to use the phone in a few minutes, sir, to try to post the bond. The jail's also going to give you a notice for your court date, which will be April the 7th at 8:30 a.m. before Judge Garcia. Mr. Sawyer, do you have any questions?
No, sir.
All right, sir, wish you the best. No contact with alleged victim or that property. Andrew Boswell. Mr. Boswell, good morning. Mr. Boswell, you're here because you've been accused of one count of aggravated assault with a deadly weapon. Mr. Boswell, I've read the complaint in your case. There is probable cause, but it appears to me you have no prior criminal history at all. Is that correct?
Yes, sir.
And you're currently active duty. Is that correct?
That is correct.
All right, that's very good. So let me see if the attorneys have any additional information, Mr. Boswell, and we'll go from there. Mr. McDaniel?
No, we just asked for a bond.
Do you prefer a cash bond over release? I have no problem either way. It's
Cash bond, Your Honor.
Mr. Mitchell.
We have no objection to a cash bond, but we would also like the court to take into account that he allegedly admitted pre and post Miranda to pointing the firearm. So we would also request that he not be allowed to possess any firearms while on bond.
How do you suggest you deal with that with him being in the Army?
Oh, I didn't know about that. I guess.
Except for work purposes?
Except for work purposes, yes. I mean, we could take it out. I mean,
I think under this circumstance,
yeah,
he's got no history. So normally we would talk about possessing a firearm, but it appears you're active duty in the U.S. Army. You have no prior criminal history whatsoever. So given those facts, the state's not asking for that normal condition. Mr. Mitchell, is that right?
Yeah, that's right. I missed that he was in the Army right there.
No problem. Mr. Boswell, I'm going to set your bond at $500 cash. It normally would be a $5,000 surety bond, which would be the same thing as $500 to a bondsman. So your bond is $500 cash. You have the standard conditions of every bond, plus you've got a condition of no contact with the alleged victim, no contact at all. I don't even know if you know this person, so that shouldn't be hard. Just stay away from that person. You will get to use the phone in a few minutes. As soon as you post the bond, you'll be released. The jail's going to give you a notice for your next court date. That court date would be April the 7th at 8:30. If you choose to hire an attorney, that court date may change. I'm not sure about your deployment status, but you may want to consult an attorney when you're released if you choose to do so. Any questions?
No questions.
All right, sir. I wish you the best. Next, we have Zoe Morris. Ms. Morris, good morning. Ms. Morris, you're here this time for battery on a detention or a commitment staff. Ma'am, there is probable cause. I think you were sentenced just perhaps last week, within the last week or two. That was a misdemeanor battery. This is a battery on detention facility staff, which is a felony charge, Ms. Morris. So I think you're entitled to a bond as far as I can tell. Let me hear from the attorneys before I set that bond. Mr. McDaniel?
Nothing, Your Honor. There's also a hold from Doug, but nothing else.
Thank you. Mr. Mitchell?
Nothing from the state, Your Honor.
So you do have a hold from DJJ. It's not on my jail sheet, but I know this incident allegedly occurred at Department of Juvenile Justice facility. So it's reasonable to assume you have a hold because you were under a commitment there from a juvenile court judge at somewhere in the state. So Ms. Morris, your bond today is going to be $7,500 because you just got out of jail for the very similar allegations of kicking a staff member. For whatever reason, you were only charged with a misdemeanor at that point. But as I mentioned, it's no longer the case. Your bond is $7,500. You have a condition of no contact with Dove Academy for now, no contact at all. So if you post this bond, you're not going back there. They may take you somewhere else, but you're not going back there. So if you post the bond, they're going to have to figure out where to put you at in some other kind of temporary holding facility. And you've got absolutely the condition of no contact with the alleged victim in this case. Ms. Morris, you have the right to use the phone and you'll get to use the phone in a few minutes. Do you have any questions, ma'am?
No.
Judge,
Right, have a good day.
Just clarification, I don't think she'll have no choice in it. I think the judge in South Florida is the one who had ordered her to go there, so it kind of be she's gonna be here a while anyway, but just to say that, you'd have to, that order would have to go away, I guess. I don't know how that works, but,
Yeah, and I don't know, I think the most recent order is going to be the one that's controlling. And since she's now been charged with kicking 2 different staff members on 2 different days, she's not going back to that program, at least not now. So if DJJ if you post bond, DJJ will put you somewhere else so we can figure out where to go. But we're just endangering the employees of that program, it appears, and I'm not going to do that. So you can't go to that program, and that's not your problem to deal with. That's DJJ's, but that's only their problem if you post bond. Any questions, ma'am?
No, sir.
All right. As far as the court date, we need to give her a court date, Corporal, for April 7th at 8:30.
yes, we got it.
Thank you. Is that 7,500? Yeah, can you tell them I can't? I don't know what they're doing over there, but I can't. Sorry, Mr. McDaniel, we got some commotion going on next door. So I said $7,500 bond, no contact with Dove Academy.
And the victim.
Or the alleged victim. This is State versus Dwayne Lawrence. Mr. Lawrence, good morning. You're here because you've been accused of 1 count of possession of methamphetamine, 1 count of introduction of contraband into a detention facility or county jail, and 1 count of petty theft with a previous theft conviction. Mr. Lawrence, there is probable cause for those 3 charges. I'm appointing the public defender's officer to represent you. Mr. Lawrence, I'm going to ask that you listen to Mr. McDaniel, and then I'll address your bond status. Mr. McDaniel.
Just fine, Your Honor.
Mr. Mitchell.
We request that as a condition of his bond, he be subject to random UAs.
Thank you. Mr. Lawrence, when I looked at your criminal history on the Department of Corrections website, it appeared to show 5 prior prison sentences, 5 separate prison sentences. So I'm going to set your bond at $7,500 in each of these charges. Mr. Lawrence, that makes your total bond $22,500 cash or surety. You do have a condition of random urinalysis, and you do have a condition no contact with any Dollar General. So if you do post a bond, Mr. Lawrence, you can have no contact with any Dollar General, and you will be drug tested at some point, most likely by a judge or at a judge's request. Mr. Lawrence, you get to use the phone in a few minutes, sir. If you post the bond, you're going to be released. If you don't post the bond, Mr. Lawrence, the public defender's office will be in contact with you, and I'm going to ask the jail to give you a handwritten notice for your court date, which should be April the 7th at 8:30. Mr. Lawrence, any questions, sir?
Sir.
Wish you the best, Mr. Lawrence. We have Tyrone Godfrey. Next. Mr. Godfrey, good morning. Mr. Godfrey, there's a violation of state probation warrant that's been signed in your case. I'm looking at a copy of it now. Judge Garcia has signed a no bond warrant. So what I'm going to do today is I want to go ahead and get you arraigned, which means I want to get you a lawyer appointed if you're asking for one in this BOP. Would you like to have an attorney appointed to represent you, Mr. Godfrey?
Yes, sir.
I'm going to appoint the public defender's officer to represent you, Mr. Godfrey. Listen to Mr. McDaniel. We'll see if you have any questions in just a moment.
Yes, sir. Your Honor, we're going to plead not guilty as this on the April 23rd docket, and I advise you, there'll be an attorney from the PD's office. I'll come speak to him prior to that hearing.
Thank you, Mr. Mitchell. Anything?
Nothing from the state.
So, Mr. Godfrey, April 23rd, attorney will see you before your court date. Any questions, sir?
No, sir.
All right, sir. Wish you the best.
Yes, sir.
We have Dalton Parker next. Mr. Parker, good morning. Mr. Parker, you're here because you've been accused of 1 count of driving under the influence. Mr. Parker, there's probable cause for the charge based upon the complaint affidavit that's been filed, but it's a very, very low breathalyzer for a DUI case. Now that you can have non-breathalyzer DUIs, and you can also have other substances that don't show up on a breathalyzer. But in this case, the allegations are that your breathalyzer was .068. So it is what it is. Mr. Parker, I think I saw no prior criminal history at all. Is that accurate, sir? Actually, that's not correct. It's almost nothing. 2017, something with a pawnbroker, but that's all, right?
Yes, sir. That was when I was in high school. Yes, sir.
Well, there's some out-of-state stuff too. Texas, you've been in Texas before?
Yeah, but I've never been in trouble in Texas.
2019, Dalton, let's see if it's the same middle name, Dalton Gage Parker, drunk driving, September 13th of 2019 in the state of Texas. It looks like on an Air Force base, maybe.
Yeah, that happened, but that happened at Eglin Air Force Base in Valparaiso, sir. Not in Texas. I don't know where they got Texas from.
Lackland Air Force Base in Texas?
No, sir. It happened at Eglin Air Force Base over there by Destin. Yes, sir.
Okay. It's not going to make a difference today. And the reason it's not is because this DUI charges. Mr. McDaniel, how would you characterize it? I don't know the word to say. It's problematic.
Yeah,
It's on the week. Yeah, there's some issues with the DUI charge. It's a difficult case to prosecute. Not impossible. I'm not the judge of that, but it's certainly going to be one of the more difficult cases for Mr. Mitchell to try to figure out what to do with. So for that reason, he's probably a conditional release candidate. Mr. Mitchell, anything from the state?
No objection. Just he'd be subject to random UA since there was alleged cannabis involved in this.
Mr. Parker, I'm going to let you pick between the bond and the conditional release based on your criminal history and the circumstances in the complaint. If you want to post the bond, it's $2,500 cash or surety. The bond would have the standard conditions of every bond, plus it would have a condition not to possess or consume alcohol because it's allegedly there's some alcohol in your system, and you would have a condition of random urinalysis. I'm going to also offer you a conditional release. Conditional release would have those same conditions plus the normal conditions of conditional release. I know that Mr. McDaniel's already gone over the choice. Mr. McDaniel anticipates what I'm going to do, and he's very good at it. You have any questions about your choice between bond and conditional release?
Just choose. Conditional release, Your Honor.
I'll tell you more.
Oh, really? Okay. All right, so I'm gonna grant you the conditional release. You'll have the standard conditions of release that I mentioned, plus those special conditions of random urinalysis and the no alcohol is a standard condition of a release. I'm also going to ask the jail to give you a notice for your court date, or we can give the notice here on conditional releases, right? So the notice will be for when?
The 30th.
So when you get to the courthouse and you meet with the conditional release officer, they're going to give you a notice for March 30th at 9 o'clock. That will be your court date, Mr. Parker, and they'll give you that notice when you get here. They'll get you to sign it. They'll give you a copy of it once it's signed. So if you do use the phone to contact friends or family, Mr. Parker, you can tell them that you can be picked up at the courthouse in roughly 30 to 45 minutes. Mr. Parker, any questions?
No, sir, Your Honor.
Wish you the best, sir. So we have Goya Wilson. Here. Ms. Wilson, good morning. Ms. Wilson, you have a hold for Orange County. It appears to me, it looks like the best I could tell, there are two bonds set on two different cases. One's a $2,500 bond and one is a $2,000 bond. Mr. McDaniel, does that match what you've got?
Yes, Your Honor.
So, Ms. Wilson, I'm going to ask the jail to verify that and double check that. If you post the bonds, you'll be released and you'll go to court in Orange County later. If you're not able to post the bonds, the public defender's office, if you're not able to post the bonds, you'll be transported to that county. If you're still here in 15 days, you'll come back for a review to see what's going on with the transport. Mr. Mitchell, anything from the state?
No, Your Honor.
Ms. Wilson, do you have any questions?
Yes.
What was her total bond?
Judge, she's been sentenced to between 9 years, so she's not going nowhere, and she just wants you to know that, and she also wants you to know she was in jail, which I already explained all that information to her, that she just needs to take it with her, whatever she wants to take, if she doesn't post the bond, when she gets close to getting out here.
Okay, so I apologize. That's not on my jail sheet. I had no idea you'd been sentenced to a jail sentence. So Corporal, if they can put that on the jail sheet, that would help possibly avoid confusion. I'd appreciate that. So Ms. Wilson, what will happen, ma'am, is there's a chance you can resolve this while you're here. That's rare. It usually doesn't. It's not very common, but if it happens, good for you. So if it doesn't happen, when you get close to the end of your sentence, you get down to about a week or 10 days, they'll do another warrants check. If that county still wants you and says they're going to come get you, then you've got to hold you for them. And you have the right to post a bond when you finish your sentence here. On the other hand, if you're not going to post a bond, you may go ahead, they may transport you down there a few days early so you can get to Orange County and deal with the allegations against you down there. Any questions?
Yes, I was just wanted you guys to know that I was in here. I was picked up in Orlando during the time that I had my court date. So it's like didn't miss it on purpose.
You're picked up in Orlando when you had your court date here? Are you?
No, she was in jail when she had a court date, and I've told her that we're not the ones. She's going to tell us that, so we clearly know about this, but we're not the ones that you need to tell. You need to tell Orlando that, not us.
Ms. Wilson, were you in our jail or were you somewhere in
Yes.
between there? Okay, so what I'm
Yes,
gonna do is when you're released, I'm gonna ask the jail to send you documentation with you. That documentation will show the day that you were arrested here. And then when you get there, you can show your attorney or the court there that you were in jail. Now, it may make a difference and it may not, depending upon the circumstances and whether or not you were charged with a crime after you were on bond. I have no idea. But we'll at least send the paperwork with you and you can show them, okay?
Thank you.
Yes, ma'am. Have a good day. Mr. McDaniel, we have Corporal. Wait till Corporal gets back in there so we can make sure we're all on the same page. You have an officer in there, Mr. McDaniel?
Yes, I do.
Sergeant Gross or Officer Whitakerson?
Whitakerson.
So Officer Whitakerson, we have state of Florida versus, I think it's William Tony McCron. Am I getting that right?
I think that's correct. Your
So Officer Whitakerson, he is currently serving a sentence for 5 months and 29 days for a contempt hearing and finding. Mr. McDaniel has been working on his case and trying to get an evaluation done, and his mental health has not improved. And I'm considering amending that sentence. Mr. McDaniel, and I know that Live Management wouldn't do anything in writing because he won't cooperate with an evaluation. But Officer Whitakerson and Mr. McDaniel, somebody tell me, my understanding is if I sign this order that I've typed up, changing his sentence in the contempt to time served, there's going to be a Baker Act evaluation at least. And the results of that evaluation, will determine what happens next. Is that right, Officer Whitakerson?
Yes, sir.
Is Tammy here today or?
I haven't seen her this morning.
She was here yesterday. I don't know if she's here today,
We would have to call her.
we'd have to call her, but she was gonna write it up when I talked to her last week and yesterday. I'm not sure if she's here today though, so,
Well, your email says she wouldn't put anything in writing.
Not in writing to you or to the court or to anyone else. I mean, she's gonna write up
Because
Baker
he
Act.
hasn't signed a release.
Correct.
Okay.
Yeah. HIPAA law. She's not gonna say anything about it.
Yeah.
She's gonna write up a Baker Act.
Okay. So, Mr. McDaniel, your request is that I want to make sure I'm on the same page, and we got to figure out the date for the criminal case. Your suggestion is that his mental health has not gotten better, and I have no reason to doubt what you're telling me. It may have actually gotten worse, and that he needs immediate mental health treatment. Is that right, Mr. McDaniel?
Yeah, I'm just gonna say the facts of the case. That's the facts of the case. I don't want to make any recommendations because Mr. McCrone is Mr. McCrone. I'm just saying those are the facts that I know of is that his mental health since he's shown up, has done nothing to deteriorate worse. And I've had indicators from the jail and other people here that they're worried about his mental health. And that it's.
Thank you. That's what I was understanding. And Corporal, you agree with that assessment based on what you're seeing?
Yes, sir.
Okay. So what I'm doing is I'm signing an order amending the sentence in the criminal contempt case, Corporal, to 24 days with 24 days credit. So basically the criminal contempt case is over. I've just signed that 10 seconds ago. It's signed. I'm going to ask Dawn to send that to you. So he's through with the contempt sentence. And the purpose for that, as I say in this order, is to try to get a mental health evaluation because I don't want his condition to get even worse. At the time I sentenced him to that, in the back of my mind, I was thinking we would amend it at some point, possibly to inpatient drug treatment, which is what he asked for. That hasn't worked out. So he'll be through with that. That leaves the criminal case, which is 26-85 MN, which he currently has a bond of $2,500. He still can't go to Baker Act until we resolve that bond. So, Mr. Mitchell, what's the state's position on that bond?
Given what was discussed yesterday and the issues he may have with the conditional release, the state has no objection to just, if the court is inclined, to give him an ROR so that we can get him to the Baker Act facility as soon as possible.
That seems to be the most appropriate thing to me. Mr. McDaniel, any thoughts on that?
No issue with that, Your Honor. Maybe set it for the May arraignment docket instead of April. April's about but 2 weeks, less than 2 weeks away.
The May docket, Mr. Mitchell, will be, it may fall in April, it may fall in May. April 27th, Mr. Mitchell.
No objection.
April 27th, Mr. McDaniel.
I think it'll be better and hopefully he can understand it. I don't think he can understand it right now, but maybe they send something in writing to him.
So that's a great point, really. Let's give him a written notice, but I'm also going to ask the clerk to mail him a notice. I know a lot of times you don't send a mail notice, but given his mental health status, we'll do both. So Corporal, if y'all will give him a written notice for that date, and then please contact whatever your normal procedure is, whether y'all do the Baker Act, whether you contact Makes Life Management, that's whatever y'all's normal procedure is, and we'll see him then. Can I do a condition to, well, he's not in condition to follow it. The email that I got from Mr. McDaniel that he copied all of us on, Life Management recommended a condition that he comply with orders basically of doctors, but if he's not in the condition to follow it, then what good does it do? And I don't know if you can put that kind of condition on the ROR. So I'm not going to try to muddy the waters any. It's just going to be a regular ROR, and hopefully he'll go to Baker Act and they'll deal with it down there. I'm giving him an ROR today. On the criminal case, not qualified for Baker Act, then first of all, I'd be shocked because both the jail, Mr. McDaniel, and indirectly Life Management have all said he does qualify. But if he doesn't, he doesn't, and he's entitled to be released. But that would be a huge change.
My only, he most definitely qualifies. I just don't know if they can get him resolved in 3 days. I think it's going to take longer. I think it's gonna take a while to get him back.
But he does
straightened out.
qualify.
I'm
Oh,
more
absolutely.
concerned about his mental health than I am him
There you go.
hurting my feelings by cussing in court, frankly. So we'll see if this one can get him some help, hopefully. So that's all I had today, gentlemen. I may have missed something. I'm not sure. Mr. McDaniel, anything else from the public defender's office?
Nothing else, Your Honor.
All right, friends, they've wrapped that up down there for the day. Let's go up to Ohio. Judge O'Donnell, always a good time.
All right, this 22-455 Justin Poole violation of community control. First violation, failed to report October 7 and thereafter. You understand that charge?
Yes, Your Honor.
Second, home visit was attempted October 23rd, and you did not live at that address nor provide a alternate address. You understand that charge?
Yes, Your Honor.
Ms. Novotny?
Your Honor, at this time, my client would like to waive both hearings and admit to the violation.
Is that what you want to do?
Yes, Your Honor.
All right, what's your plea to those allegations?
Guilty.
Accept your guilty plea and find you guilty. What seems to be the problem?
I started drinking a little bit and I was behind on my rent. So instead of facing my consequences, I chose to run from them. And here we are.
That was a good long-term solution.
No, no, it wasn't.
Okay.
Yeah, you know, we do things sometimes when we're scared. We don't think in the moment.
What are you
but
scared
looking back. I don't know, because I had a good relationship with Miss Newman, my former probation officer. I'm not really sure what I was scared of, the consequences of my actions, because I had prior seen you about leaving a different sober living house, and seeing you 2 times in a row on the same thing seemed like a bad idea at the time.
Well, did you think you were never going to see me again?
No.
Why
no.
did you leave the sober living this time?
Non-payment. By the time I found a job I worked at a meat cutting place called Barb and Patty's.
Right.
The rent was like $700. By the time I found the job, I was almost a little over $1,100 in the hole. And they take at the Jeff's house, they take the payment thing very seriously. The second you get X amount of dollars behind you, you have to leave within 24 hours anyways.
Okay. And so then naturally, the thing you thought to do was call your probation officer and discuss that problem with her, right?
No.
No. And so what'd you do then for the last 4 months, 5 months?
I've been living with my dad. I was looking for work a little bit. I was actually in the hospital with a staph infection in my face for the end of December into the middle of January, until I figured out my insurance lapsed. I left there. I got a $90,000 bill in the mail, and then I went to go reapply for Medicaid and my food stamps mid-February, and I was told you can't get back on health care and stuff with a warrant out for your arrest due to new policies, which I didn't know. So when Wilk Police came to my house, I just opened the door. I can't, I have bad heart disease and stuff. I can't live without health insurance. So that it was the end of the line, and I took it instead of running or hiding again.
So why did you stop working at Barb and Patty's?
Because I moved back to my dad's house. I have no transportation back to Menor.
Damn, I thought we had this bus system called Late Tran.
Yeah.
Did you ever utilize that?
No.
Why not?
I don't know. I've never ridden the public buses.
So? Why didn't you drive a car?
I owe a lot of money.
Okay, why?
Past court fines. They all got sent to the Attorney General's office, and you had to pay lump sums there.
Is that right?
Which
Did
I
you
don't
talk to
possess.
somebody at the Attorney General's office?
Yes, Your Honor.
It seems like you have no interest in digging yourself out of this hole.
I believe it would take far too long.
Okay, so what now?
I don't know what now.
Why else did you get booted out of sober living?
That was it, just the drinking and non-payment.
You said, well, you only told me the non-payment. What's the drinking thing?
The drink, I said I started drinking again was one of the first things I said.
Okay. See, I lost track of you, okay? Because you're on page 2 of a docket sheet.
Right.
So, did you have something at the sober living that got you in trouble with them?
Yeah, I found a beer can.
A beer can. What kind of beer?
A Four Loko, I believe.
The hell's a Four Loko?
A beer?
A beer? I never heard.
I think it's a malt liquor. I don't know.
What's your heart problem?
I mean, I have the valves now, but it was mitral, aortal valve something and mitral valve something. So I got the mechanical valves changed out. I had a heart murmur, which is a hole in your heart, which they patched, and now I'm on blood thinners.
Yeah, one of the things you can't understand is why you can't smoke dope. Why do you wonder that?
It's not that I can't understand it, it's that it doesn't affect my life like doing cocaine did. Like the first time I saw you when I was doing that, it's not.
It's not what?
It doesn't adversely affect my life or my relationship with
You're
my
in
family.
fucking jail.
Yeah,
How has it not affected your life?
I don't constitute it to smoking pot.
You don't. Well, goddamn, you got a pretty good handle on what's going on. You're 32 years old, going on 33. You're in jail because you're afraid to show up to things. You got a long record, and you got a good grip on what's good and what's not good. That's great. It works out well. Your plan in life seems to be not what am I going to do tomorrow, what am I going to do an hour from now? Because all you're trying to figure out right now is how to get the hell out of jail as soon as possible and get off of probation as soon as possible. So what's your method? What's your solution to getting off of probation as soon as possible?
To run the time out on the probation clock.
How do you run the time out on the probation?
You do the time on your case.
You do the time where?
Wherever you can. It's a felony, so prison.
Okay. And what awaits you in prison?
Not sure. I haven't been there.
Not sure.
It's better than.
You're afraid to show up here, but you're not afraid to go to prison? No?
No.
All right. Then what's your plan after you get out of prison?
Find a job and continue working. Pay off my giant court fee or attorney general fees and get my license back and continue on with my life.
Why didn't you do that while you were on probation?
I was doing it slowly. Except for the sober living, I've done everything that you've ever tasked me to do.
Oh, well,
NeoCap,
didn't show
IOP,
up.
aftercare.
you don't like showing up.
Yeah.
So what good did all that stuff do if you're of the belief that you should be able to drink and smoke pot?
It got me off hard drugs. You helped me repair the relationship with my family. I sowed new friendships and
How much pot were you smoking while you've been gone for the last 5-6 months?
not that much.
Not that much. Well, how much?
It's just a couple grams a week because I wasn't working. So
what does that have to do with it?
So I'm not blowing tons of money on pot. I have other things I need to pay for, such as the court fines or attorney general fees, I should say.
So how much money were you spending a week on that?
None. I know people that grow it, so none, to be honest.
So what good did any of this treatment do?
It got me.
If you're gonna go out and smoke pot?
It got me off cocaine, which adversely affected my life way
So
worse
that's the
than.
cure to getting people off of cocaine and heroin and whatever else is letting them smoke pot?
I don't know. Everybody's cure would be different. I suppose.
Any of this treatment that you went through, anybody ever talk about insight? Remember that term, insight?
Yeah,
And what do you know about insight,
everybody has a different version of it.
a version of it?
Yeah.
What's your version of it?
My version of it is, I could see things one way and someone else can see things another way.
Okay. How's your way working out so far?
I don't know, I haven't been off probation in a very long time.
Well, your way's not working out
Okay.
because you're in jail again.
Mm-hmm.
I know you don't believe that, but it's objectively true.
I can't deny it, I'm sitting here in
Well,
shackles and handcuffs.
But you don't believe it, you just won't deny it. Because you have no insight into what the situation is, what your problem is, how to get out of your problem, how to begin to dig out of the hole that you've created over 32, 33 years. Because you don't have any interest in doing that, okay? You had a pretty good opportunity at this Barb and Patty's place to learn how to be a butcher.
Mm-hmm.
And you pissed that away for, why? Why'd you do that?
Because I run from consequences, I guess it's what I'm good at.
All right, well, you're not good at it because you're caught.
Mm-hmm.
You're here again. How many days on this felony 5 have you spent in jail?
244, 43, something like that.
So you've eaten up 8 out of 12 possible months. And have really haven't accomplished anything. You think you've accomplished something because you tell me you haven't taken any cocaine since you've been gone. Of course, I have no way to verify that because you've been gone. And when you got caught, you wouldn't take a screen. So that tells me quite a bit. Of course. You give me the eye roll like, you know, I'm out of my mind. And
No,
to
Craig
believe
Berry,
that you were using cocaine out there.
Craig Berry visited me, I believe 2 days or 3 days, and I tried to pee for him. He waited all 40 to 70 seconds and then said, well, you gave it a try, and
So it's
left.
Craig Berry's fault.
I'm telling you factually what happened. I'm not saying it is anyone's fault.
You're not a good factual reporter. Ms. Novotny?
Your Honor, we would just ask for any leniency when it comes to the probation violation in front of you. From my understanding, he does have a total of 243 days of credit. I know in the time being, he was trying to achieve or get a job with Goodwill or Marks before the violation occurred. I know sober living became very expensive for him as well. He was living, from my understanding, with his parents. With that, he does have a lot of medical issues dealing with his heart disease, congenital heart disease, previous valve replacement.
He's not all that concerned about his medical problems because he's out drinking 4 Locos and smoking pot. So his medical condition is secondary to him.
He also has previous valve replacements and endocarditis. He's on blood thinners for the rest of his life. With that, Your Honor, he was doing counseling with Lake Geauga. He does have a support system that is present in the back of this courtroom. We're just asking for any type of leniency today.
What good does a support system do if you won't utilize the support system?
I do.
You do. How? Smoking pot? Exactly how have you utilized your support system?
I talk to them when I feel like I'm gonna do hard drugs and things like that.
And they
or
tell
when
you
I'm
to
gonna do
just smoke
something
some
crazy.
pot instead?
No, they don't.
How do you use your support system known as the probation department?
I don't see the probation department as a friend.
You don't. I didn't ask you if they were your friend. I said, how do you utilize the support system that is the probation department?
I went to my meetings. We're ignoring the fact that I showed up to tons of appointments, took hundreds of drug tests for a year, 2 years.
You haven't
And then-
been there since September 23rd.
That's 4 months since 2023.
God's sake.
I wouldn't argue.
No insight,
That's not gonna help you.
zero insight. You're right, they're not your friend, but they're certainly not your enemy, although you treat them like your enemy. Who is your probation officer?
Nicole Randazzo, then Nicole Newman.
Right? Who is it now?
I don't know.
Because Nicole Newman left.
I don't know.
When did Nicole Newman leave, Kaylee? Do you remember?
Probably around November, I believe.
Okay.
Could have been October.
All right. All right. Anything else you want to say?
Yeah, maybe you're right about me in some aspects, but, I don't know. I don't know how to fix the problems, your guys' way, I guess.
Well, you haven't fixed it your way. So maybe what you should have done was try it a different way.
I gave it a real good shot.
You didn't. You didn't.
I thought.
You did. The only one that's gonna fix you is you. You are no longer amenable to community control. I'm going to terminate your community control, and I'm going to sentence you to 11 months in prison with credit for 243 days and the costs. So you won't have to report to probation anymore. And you can do whatever you want to the extent that you don't get caught. Because if you're going to stay around Lake County and you get caught, guess where you land again?
Mm-hmm.
All right.
I had to write this one down. I don't know how to fix problems your guy's way, or your guys' way, as he said. By definition, you do what they tell you to do. I mean, is it that hard to figure out? I mean, really. They're telling you what to do, so they're giving you the instruction manual. They're writing it out for you in crayon. Do what you're told. Not that hard. But you know what? Is he any different from the vast majority of people that we seem to see here who just make things hard? Probably not. Anywho, Great Grand is Judge O'Donnell only stream one time each day. Yeah, he opens up his stream at the beginning of his docket, and then it just runs, and he comes in when there's something to do. Should put Ellie cam on. Well, Ellie's not in her bed right now, so I would just be showing you an empty bed if we put on the Ellie cam. All right, let's go to Texas. Say good morning to Judge West.
Okay, thanks, Shoot. All right, yes, all right, are you Elaine St. Clair?
Yes, ma'am.
And Mr. St. Clair, you were previously in court in cause numbers 23 DCCR 2044 and 23 DCCR 2117. Entered pleas of guilty in each of those cases. I've received the pre-sentence report. Has everyone received that report?
The defense has, Your Honor.
State has. Are there any additions or
I
corrections?
think we need to correct some stuff, Your Honor, if we can swear him in and let me ask him some questions.
Raise your right hand the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Okay, go ahead.
Ms. St. Clair, in your PSI, you stated that doing your interview, you stated that you were in the wrong place at the wrong time. Is that correct?
Yes, sir.
And you understand that being there and participating in this is the same thing as committing the crime, correct?
Yes, sir.
Okay, so you did commit the crime.
Yes, sir.
Okay, and you also said somebody said you did something you didn't. You're talking about you weren't the one planning this, organizing this,
Yes.
but you were involved in it.
Yes, sir, I was involved.
Okay. And as far as the thing about just taking probation just to be out of jail, is that you took probation because you don't want to go to prison, correct?
Yes, sir, I don't want to go to prison.
Okay, all right, and you understand that's the other the options are go to prison, take probation, or go to trial, correct?
Yes, sir.
Okay, and you thought taking probation was the best option.
Yes, sir.
Okay, and you are guilty of this, and you did do this.
Yes, I did.
At least you participated in this, correct?
Yes, sir.
Okay, all right. Pass the witness, all right?
Anything? No.
Okay.
So, Mr. St. Clair, obviously, we've had numerous conversations here about
Mhm.
kind of the, a few things. One, the opportunity that you're being given
Yes, ma'am.
with these probations, and also with what's going to happen and the jail disciplinary and following the rules and things like that.
Yes, ma'am.
One thing I can say, and I'm pleasantly surprised, is that you haven't had a jail incident report since we had our last really serious conversation about that.
Yes, ma'am.
And so I appreciate and hope that maybe you have grown up some and will continue to do that so that you can be successful and live a whole different life than what you've been doing.
Yes, ma'am.
So I'll go over some conditions and some more instructions in a minute, but first I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily.
Yes, ma'am.
Find sufficient evidence to find you guilty. However, in cause number 23 DCCR 2044, I'm going to follow the agreement, defer all proceedings, place you on probation for 10 years.
Yes, ma'am.
You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. And I'm going to go over some specific things that are going to apply in both of your cases in just a minute. And cause number 23 DCCR 2117, also find sufficient evidence to find you guilty, but I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 10 years.
Yes, ma'am.
You're ordered to pay the $1,000 fine in that case and to follow all of the rules and conditions of probation. One of those conditions is going to be in each case that you enter and successfully complete the cognitive track of the ISF program. And that's just a program that is intended to help you to make better decisions, to not be around the wrong people, to not be part of the lifestyle that you've been living. Otherwise, you're going to end up in prison for a long time. You'll be on the high medium caseload in each of those cases until probation finds otherwise. After you've been on probation for a while, that means you'll have to report more. They're going to keep a better eye on you. You're going to have to get your GED if you haven't graduated from high school. You're going to have to get a job and do all of those things. And they're there to help you do that. Okay, so if you're feeling like you can't do something or you're struggling or you don't have support at home, probation's there to help you. They're not trying to trip you up. Nobody wants you to spend potentially the rest of your life in prison, but that is going to be 100% up to you at this point. You're going to have to ask for the help and make that change and grow up and be more mature at a younger age. Do you understand?
Yes, ma'am.
The last thing is that a condition of your probation is that you do not get any incident reports in our jail or in ISF.
Yes, ma'am.
That will be a violation of your probation. And you're going to, if you do that, you'll be back in court before you ever get out and see the light of day again. And you could be looking in each of these cases at a minimum punishment of 5 years up to the rest of your life in prison.
Yes, ma'am.
And based on the nature of these offenses, it's not going to be y'all coming in here and arguing for some 2, 3, 5, or 5, 6, 7 year sentence. I'm sure Ms. Malvina is going to come in here and ask for something huge. It depends on what happens. I can't prejudge it, but I'm telling you right now, you better not
Yes,
get
ma'am.
in trouble, because that's the one thing that you've been doing that's been extremely frustrating to me. So you've learned how to do it. Whatever you're doing, you're staying away from the riffraff out there, and I appreciate that. Continue that. Do what you're supposed to, and you'll be able to change your life and be hopefully a success story.
Yes, ma'am.
You understand?
Yes, ma'am. Thank you.
A condition of your probation also, excuse me, in each of your cases, you are not allowed to possess a firearm at all. That means obviously you personally possess one. You can't be in a car with someone else that has one. You can't be in a house with someone else that has one. Somebody has one, you're out of there. Do you understand?
Yes, ma'am.
Okay. I'm handing you the trial court certification in each of your cases that shows that these were agreements that I followed. And so you've waived your right to appeal. Again, keep doing what you're doing. I'm really hope that you have, I'm impressed that I haven't gotten another incident report. And so I want to acknowledge that and tell you that I know that takes a lot out there and I appreciate it. Continue that.
Thank you, ma'am.
Yes, ma'am.
If I may, would the court consider continuing the admonishment that you'd given them previously about no contact with Jerron Crane or any of the other participants? I do not know who they are. He knows who they are. He knows who he was hanging around with.
Sure.
From his high school class.
So
just so that he's
obviously
not
you're
around
not
that
to,
person.
you're not gonna hang around Jaron Crane,
Mhm.
because we know him, but there were others that were involved. You need to, and you're gonna learn at ISF that when you come back out of ISF and you're on probation, that you've got to put yourself in different situations around different people. Get a job, go to school, whatever it is, go do that, go home. You know, the hanging out, if you're caught doing that with people that are also in trouble, then you're just gonna be right back in here with the violation. Okay, all right, you go back with the bailiff.
Thank you, Judge. We should all dismiss those cases.
Thank you. I'll sign those when they come through.
Alrighty, friends, TCF Live on St. Patrick's Day. Nice to have you all here once again. Hope you're enjoying your morning so far. Let's rotate back to Ohio. New contestant in front of Judge O'Donnell, and the last one was so good. Let's try again.
File 26 CR 184. We're here today for an information. It's anticipated by the state of Ohio, the defendant will waive his right to have his case presented to the Lake County Grand Jury. And furthermore, to proceed by a 2-count information, count 1 charging attempted illegal conveyance of methamphetamine, and count 2 aggravated possession of drugs for that methamphetamine. No threats or promises were made to this defendant to induce his plea other than a pre-sentence report. Thank you.
Mr. Watson.
Thank you, Your Honor. May I please the court? That's my understanding of this morning's hearing. I've had a chance to fully pre-try this matter with the prosecutor. I believe full discovery has been provided. I've also had an opportunity to discuss this matter with my client. He is prepared this morning to enter a change of plea as just outlined by the state. First, by entering a change of plea by way of information, he understands he's waiving his right to have this case presented to the Lake County Grand Jury. Further understands that he'll be waiving certain constitutional rights, and no threats or promises have been made in order for him to do so, Your Honor.
All right, thank you, Mr. Keelieber. How old are you?
33, Your Honor.
How far did you go through school?
I graduated high school.
Are you a U.S. citizen?
Yes, sir.
Are you able to read, write, and understand the English language?
Yes, sir.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication within the last 48 hours?
No, Your Honor.
Have you ever been diagnosed with or treated for any mental illness?
No, Your Honor.
Did you get a copy of the information filed in this case?
Yes, Your Honor.
Do you understand you have a right to have your case presented to the grand jury for them to decide whether or not to indict you?
Yes, Your Honor.
And did you discuss that right with your attorney?
Yes.
Are you going to waive that right?
Yes, sir.
That's just when I talk about the waiver of going to the grand jury.
May I approach?
Yeah. All right, I'll accept the waiver of indictment. Now, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you some questions. If you don't understand a question, stop me. If you want to talk to Mr. Watson some more, let me know, and I'll give you more time. Do you understand that?
Yes, sir.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes, sir.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, sir.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, sir.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them testify. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
You have the right to testify at trial if you want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, sir.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, sir.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes, sir.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, sir.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes, sir.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes, sir.
Do you have any questions about any of these rights?
No, Your Honor.
Do you still want to plead guilty to these charges?
Yes, Your Honor.
You understand by pleading guilty, you're fully admitting your guilt to the charges.
Yes, sir.
You understand by pleading guilty to these felonies, you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
Yes, sir.
Count one, the attempted illegal conveyance is a felony 4. It carries a 18-month maximum prison sentence and a $5,000 maximum fine. Do you understand that?
Yes, sir.
Count 2, aggravated possession of drugs, is a felony 5 with a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes, Your Honor.
I could give you a consecutive sentence. That means one sentence after another for the separate offenses. If I did that, you face a 30-month maximum prison sentence and a $7,500 maximum fine. Do you understand that?
Yes, Your Honor.
Do you understand your guilty plea may result in a driver's license suspension of between 6 months and 5 years?
Yes, Your Honor.
Do you understand your felony conviction will prevent you from owning or possessing a firearm?
Yes, sir.
Do you understand if a prison term is imposed in this case, you might have to serve a period of post-release control for up to 2 years under the parole authority?
Yes, sir.
If you are placed on post-release control and violate any conditions, the parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes, Your Honor.
If that violation is a new felony, you could get an additional consecutive prison sentence for that violation. Do you understand that?
Yes, sir.
If that were to occur, the maximum prison sentence for that violation would be the greater of 12 months for the time left under post-release control. Do you understand that?
Yes, sir.
Do you understand that if a prison term is imposed, you are eligible for judicial release?
Yes, sir.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 30 months. Do you understand that?
Yes, sir.
Has anybody promised you that I would be lenient on you just because you're pleading guilty today?
No, sir.
Has anybody promised you what I will sentence you to in this case?
No, sir.
Do you understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes, sir.
Have you had enough time to talk to Mr. Watson before pleading guilty today?
Yes, sir.
Has he discussed everything about your case and answered all of your questions?
Yes, Your Honor.
Are you satisfied with the advice he has given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, Your Honor.
Do you have any questions?
I do not.
Mr. Geigerich, if the case went to trial, what would the evidence show?
Thank you, Your Honor. If the case went to trial, the evidence would show that on February 5th, 2026, the defendant reported to the probation department located at 104 East Erie Street in the city of Painesville, Lake County, Ohio. The defendant was at probation and was arrested on a probation violation warrant. At that time, he was warned about legal conveyance and asked if he had any drugs on him. He indicated he didn't. He was run through the body scanner, and a baggie of methamphetamine and a baggie of Suboxone and 2 hypodermic needles were recovered from the defendant. Those items are sent to the Lake County Crime Lab, where the baggie of meth tested positive for methamphetamine, an amount of 0.09 grams. Then the Suboxone tested positive for Suboxone, and the needles tested positive for methamphetamine Schedule 2. I mentioned those last 2 items in as much as they will be forfeited as instrumentality. Thank you.
All right, Mr. Watson, anything to add to those facts?
No, Your Honor.
Mr. Keeley, did you hear what Mr. Geigerich said, that the facts would show if the case went to trial?
Yes, Your Honor.
Are those facts true?
Yes, Your Honor.
All right, what is your plea to count one attempted illegal conveyance under the grounds of the jail, a felony 4?
Guilty.
What is your plea to count 2, aggravated possession of drugs, a felony 5?
Guilty.
Mr. Watson?
All right, same form I went over with, no changes to it. I just need you to sign there and put today's date. Today's 3/17/26. This is embarrassing. It's all right. Well,
I'm just so ashamed of
we'll
myself.
get through it.
Thank you. All right, Mr. Keeley, is this your signature on this written plea of guilty?
Yes, Your Honor.
And did you sign it voluntarily?
Yes, Your Honor.
Do you want me to accept your written plea of guilty?
Yes, sir.
All right, I'll accept the written plea of guilty. Defendant was present. Mr. Watson advised of all of his rights in a knowing, intelligent, voluntary waiver. He understands the nature of the charge, the consequence of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary. Will accept his plea of guilty and find him guilty of count 1, the attempted illegal conveyance, a felony 4, and count 2, aggravated possession of drugs, a felony 5. And I'll refer this for an updated pre-sentence report. Sentencing will be April 15, 1 p.m., and the bond is revoked. Anything else, Mr. Geigerich?
Nothing, Your Honor. Thank
Mr.
you.
Watson?
Nothing further, Your Honor.
All right, we're adjourned.
Okie dokie, friends. Let's do this. Let's go down to Louisiana. We haven't been there in a little while. See what's going on with the parole board.
It's 8:50. Today's date is 3/17/26. Serving with me is Mr. Byra to my right, Mr. Tillis to my left. My name is Pete Freeman. I will be the acting chair. Would staff at headquarters introduce yourself, please?
Whitney Trostclair? Sure, I'll be.
Okay, Mr. Jupiter, is there any staff there with you?
Yes, sir.
Could they introduce themselves real quick?
Lieutenant Ball?
Okay, Ms. Ball, is there anything you want to tell us about Mr. Jupiter?
No, sir.
Okay, thanks for having us today.
Not a problem.
Today we're here for your revocation hearing. Please state your name and your DOC number.
Jalen Jupiter, 767608.
767608, okay. Do you have a parole questionnaire with you?
No, sir.
Okay, we're gonna put one up on the board and tell me if that's your signature.
Oh, yeah, yes, sir. I do have one with me.
Okay,
Yes, sir.
you understand you're not eligible for appointed counsel today? And that if you wanted appointed counsel, you would have had to hire. Do you
Yes, sir.
understand that?
Yes, sir.
Do you want to proceed today without appointed counsel?
Yes, sir.
Okay. I was assigned your case, so I'm gonna go over it. I'm gonna read your violation. You're to plead guilty, not guilty with or without a statement. Okay, it is alleged that you violated condition number 4. I will not engage in criminal activity, nor will I associate with people who are known to be involved in criminal activity. You'll avoid bars and casinos and refrain from illegal use of drugs, alcohol. You're charged with the subject failed to refrain from criminal activity as evidenced by his arrest by the St. Charles Parish Sheriff's Office for domestic abuse battery, burning, serious injury during this period of supervision. On 12/4/25, based on note of evidence taken in open court, the charges against Mr. Jupiter were null pros by the district attorney's office. How do you plead to that charge?
Not guilty.
Okay, tell me what happened.
Me and my girlfriend, we got in a verbal altercation because she found out about another female that was expecting in like December, and she ain't want to see me she wanted to see me in jail. because she knew what it could have did, and I don't. It was
Okay.
more of, it was just
All
like
right.
it
So
was a
how
verbal
did she
altercation.
how did she get the knot on her head?
I don't know. That's like I never saw it. Like I never saw.
And they got pictures of it and the marks on her knees. I guess you didn't see those either.
No, I never.
So what was the argument about?
Me having another female pregnant.
Okay. What, so you saying she did this just because she was mad? But y'all still seeing each other?
No, we ain't been conversating. So I've been in jail ever since.
Right. Been in jail what? Let's see, 7 months? No.
Like 5.5.
5 months in jail. Okay. And the other one is that you didn't pay your fees. So what you got to say about that?
I could plead guilty to not paying the fees, but I still had another comment on the other situation.
What's that?
Like the judge in court, they arrested her for like falsifying a police report. And she had got arrested for it. That's why they dropped the charges in open court. She took the stand in open court and they arrested her.
All right. It's interesting. Do my colleagues have any questions?
Do you have any proof of what you just said?
Yeah, is there any way we can get proof of that?
Excuse me, Ms. Kim. Is it a way? Because my PO for attorney proof that she went to jail on the open stand. It's in my court minutes though. Yeah, she was supposed to send it over. It's public. I know it's public. It's public records. Like, but
But we can't look up St. Charles, can we? Okay.
How did she get burnt?
it was. How did she get burnt?
Yes.
She never got burnt. When I first came to jail, my 72-hour hearing, the judge dropped it down to a misdemeanor because she said she saw the police report was messed up and stuff like that. So they dropped it down to a misdemeanor in 72 hours. But I had the parole hold, so I had to sit in jail. She never got burnt. I think it's just, I don't know. She never once got burnt. The felony was dropped the first 72 hours.
She said, Ms. Stipes stated I had to go to court about this. Me and him didn't get into it. I wasn't honest and I had consequences. I had to write a statement. It was me and his cousin that were fighting. I was upset because he had other kids on the way. I did it to be spiteful. I couldn't live with him being violated. I can't live with him being violated. He was trying and he had been doing well. It was right what I did. It wasn't right what I did. He wasn't faithful, but he was trying to turn it over a new leaf. I spoke to the DA and I had consequences. Okay. He was trying to diffuse the situation with me and his cousin. I was upset and flagged down the officer. In the past, we got into it, but it was 4 or 5 years ago. I'm not afraid of him. We're not together. He's trying to do better for himself. He's just not ready to be faithful. We can't be together, and I didn't work it out because I want the best for him.
Okay. All right. I have no further questions. I'm ready to vote. Is my panel ready to vote?
I'm ready.
Okay, in light of the circumstances with her letter and also that the fact that you say that it is a fact that your charges have been dismissed, my vote today is going to be to reprimand you. You've been in jail for 5 months and that you stay away from the victim. You have no contact with the victim. Do you understand?
Yes, sir.
Do y'all have any children together?
2.
Okay. Try to, when you got to get your kids or something, have somebody with you or, have them
Bring the
drop
police-
off?
I'm bringing the police officer with me.
Okay, that'd be great. That's what I want. I don't want you getting arrested for nothing else. Okay?
Yes, sir.
That's my vote today, Mr. Tillis.
I concur.
Mr. Byron.
I concur, and I also add a special condition of attend and complete an anger management course.
Okay.
Yeah. But
So you know how to deal with that kind of
Yeah,
situation.
they'll get with you. The officer will tell you how to take that class.
Yes, sir.
Okay, so today your parole is not being revoked, and we added a special condition to stay away from the victim at all costs, and also to take a domestic abuse violence class. Good luck to you, Mr. Jupiter.
Okay, thank you.
Whenever we see those kind of things, I just think about the children. Young kids, messed up family situation, having to be handed off with a policeman present. Good stuff, let me tell you. Alrighty. There's probably good stuff going on here. Let's go to Judge Stevens' court. That's always fun.
There's 7 billion people on the planet. You're standing by yourself on it.
No.
Okay, here we are on Derek LeBlanc. That's you, sir?
Yes, sir, it is.
And Ms. Moore is here from the DA's office. And the probation office is here. You've been on probation now for, let's see. Looks like we placed you on probation September of last year. And this is 6 months has
Yes.
gone by, correct? And today we have, was this part of a result of this administrative hearing in January?
Yes, sir. We requested a judicial review before the court.
And you were to provide medical documentation relating to your so-called pain management disability. And you failed to provide that. Did you ever get it to them?
They're supposed to have faxed it over to them.
Did you ever get it to them?
I'm not sure.
They, who's they?
Dr. Craig Charles's
Well,
office.
it's, at the end of the day, he's not going to get revoked and
Yes.
go to prison. You would be
Yes, sir.
responsible for that. So I would make sure that that was done, was it?
No, sir.
It wasn't, see.
Yes.
So you can't say, well, it's the doctor's fault. These are your records. You go to the doctor's office. You sit there and say, I need a copy of my records. And you may even have to pay something for the copies. But that's your responsibility.
Yes, sir.
It's not the doctor's, really. They're busy on a million other patients.
Yes, I understand.
And so you've got to work with the staff there to get that. But that was, let's see, that was requested in January. Where are we now?
March.
Yeah, that's 2 months later.
Yes. I was under the impression they did send it.
Well, you need to follow it up. It's your responsibility, not mine,
Yes.
or the probation or the DA's office. It's yours. Your life. We're not going to be the ones getting revoked and going to prison. You would.
Yes.
That's something that I would keep me awake at night thinking, oh, did I dot my I's and cross my T's? All right. Next was, during the previous administrative hearing, you also tested positive for cocaine. And you reported that your last use was 4 days prior. Is that right? In January. You also tested positive for cocaine during the administrative hearing on this day in January. Can you explain that?
I did go out and use and
Why?
I've been dealing with some depression from when my mother.
Well, welcome to all of us.
Yes.
We all get good times and bad times, but we don't go to the crack dealer to get help.
Right.
That's a crime on my watch, on your responsibility. That's 2.
And Your Honor, since then, he's tested positive for cocaine 2 more times.
The last time, I believe, Judge, was just March 9th.
Last Monday. Yes, sir.
Also, you've been ordered to pay restitution in the amount of $1,566.54 to the victim here. And how's that going?
Well,
how's that going?
It's not going, Your Honor.
Have you paid one thin dime?
I couldn't have.
Have you paid one penny?
No, sir. I just recently got my job back.
Oh, are they giving away crack cocaine out in the field?
No, they wasn't.
Then, well, are you on, what do you have, a loan with them? No, you're having to pay them for the cocaine, but you're not paying the court-ordered restitution. I don't remember anything about a court order about paying your cocaine dealer first. Shame on you. You've got victimization. You hadn't spent one time for that. You medical because every time you use cocaine, it is a number 1 crime. Number 2, it's a violation of probation. Let's see, and what else? What about community service?
Nothing has been reported or completed through the department.
Not one moment
Yes, sir.
of community service. And there was supposed to be a theft prevention course that you were supposed to complete. Did you even enroll in that?
No, sir, I haven't.
Okay. All right. If you were in school, you get a 0, an F, you fail.
Yes.
Motion to revoke probation needs to be filed.
Yes, sir.
What do we do with him right now? We test you right now. Are you going to test positive or negative for cocaine?
Positive.
Okay, we're going to test him. And you're going to be arrested immediately. You're not leaving him.
Yes, sir.
Your Honor, he's never served any time related to this case, so he still is eligible to serve up to 180 days in county jail.
I think he's.
I served 5.5 months on that case.
As a condition of probation, he's never served any sanctioned time in the county jail.
The problem is you're not leaving here with all of this mess. This is a mess.
It is. It truly is a mess.
Well, I thought we dealt with this earlier when we placed you on probation. You made promises that you have not kept.
I made a whole bunch of promises. I wasn't even guilty of the crime. I signed took the case anyway, Your Honor.
Hold on.
Yeah. I know what you, yeah.
What am I about to do?
That I wasn't coerced or anything, that I admitted to.
No, it's even worse than that.
Is this what you're looking for, Judge?
No, the document that he signed when he entered the plea. No, I don't have it in here. I hope y'all got it.
Yeah.
This is a portion of it, Judge, that probation has in their file with his signature on it.
Yeah. Okay. These both these, yeah, she's gonna get the, that's. What I'm gonna do. Okay, thank you. Okay. Okay. This is a copy of the documents that were made based upon your plea hearing when you entered your plea here in, I guess it was September. And among other things is something that I highlighted. And I'm going to ask you to read the yellow highlight. Thank you. This was after you were sworn in to tell the truth during the proceedings, during the plea proceedings, keeping in mind what your statement was a few moments ago that you weren't even guilty of this crime. Read that.
I'm guilty of the offense and of all these, including the offenses charges against me in this case. I swear that all the foregoing as well as the testimony I gave is the truth, as God, so God help me. Sworn to and subscribed to before by the defendant on this date. I hereby certify that the thumbprint shown below and on the docket sheet and on the community supervisor's orders that are the defendant in this case.
You, that's you.
Yes.
Okay. So what you've just said, among other things, let's see, we've got, you hadn't paid any restitution as you were ordered to.
I went to jail first day before.
You're going to interrupt the court? I'll let you speak in a minute.
Yes.
We can add that. You're rude and interrupting. That's not what you do when people are in the middle of a sentence. You'll have a chance to talk.
I apologize.
No restitution has been paid. You failed to perform community service. You failed to enroll in the theft prevention programs. You have, on your own admission, consistently been using cocaine and testing positive since you've been placed on probation. And you volunteered, I'm not even guilty of this crime. Although under oath, you stated, I am guilty of the offense and all lesser included offenses charged in this case. I swear all of this is true, so help me God. So are you telling me that you committed perjury as well when you pleaded guilty under oath? That's yes or no?
No.
So you just lied to me a few minutes ago then?
Yes.
Oh, where to begin in this mess, huh? We're going to test, and you say you're going to test positive, but I want that formalized with a test. And if you test positive, what we're going to do is you will be taken into custody immediately. I'm not going to let you amble about town with drugs in your system. And the motion needs to be prepared to revoke the probation, alleging those different grounds that we've addressed. No restitution, a consistent use of cocaine, failing to perform community service hours, failing to enroll in theft prevention, and perjury. Well, you're stating after you admitted perjury, you're now changing your story and saying you just lied to me instead, which is not the right thing to do, but it's certainly not perjury. But you shouldn't lie to the judge who's directing your supervision. But you did. You're stating, is this your final answer on this? You are stating that when you pleaded guilty and were placed on probation, you truthfully admitted to guilt.
Yes.
All right, that's clear. Do you see, when we were young, what was it? When we were kids, we learned the little rhyme like story, what a tangled web we weave when first we try to deceive. You start telling one story and then it gets you caught in another story and another story, and then you're just overwhelmed. You don't know where to stop. You don't know where to fix, what to fix, because you've made so many false statements trying to concoct a story. Live honestly. Harm no one. Give each person respect. That's all you have to do. To follow all the rules. I can pull it down to 3 things. I wish some wise man came up with that 2,000 years ago, but that summarizes everything. Anyway, sit over there and I'm going to test you here in a minute. But you were in custody. Placed in custody, your probation is your freedom on probation is revoked. This court can order you to serve up to 180 days in the county jail. And at this time, I'm ordering you to jail for upfront time as a modification of your probation, which might result in a worse situation for you in the next few days when the motion to revoke probation comes out, and then we have a hearing on that. But until the hearing on the motion to revoke probation, you are ordered as a condition of your probation until, or unless it is, until such time as it may be revoked, you are ordered to go to jail up to 180 days. But we will resolve this before the end of that. And I think I've made findings that support what we are allowed to do. And we're going to need to bring a jury in a few minutes. But you're going to be taken into custody, Mr. LeBlanc, and then they're going to test you and we'll see where that works. But you're going to be undergoing your and fulfilling a condition of probation that I've just ordered as upfront jail time up to 180 days as a condition of your probation. And then we'll address what happens after I get the results of this drug test. Okay? All right. Those are the orders of the court. You're placed in the back. Thank you.
Okie dokie. Let's step back across the hallway back to Judge West.
We're dealing with two separate cases.
Entered a plea of guilty to the state jail felony offense of theft of property. The agreement was for a cap of 12 months in the state jail prison. I received that pre-sentence report. If you both had an opportunity to review the report.
Defense has, Your Honor. State has, Your Honor.
Any additions or corrections?
None from defense. None from the state, Your Honor.
All right, then.
Your Honor, I do have one brief witness, if the court will allow me.
Sure. Go ahead. You can call your
The
witness.
state calls Jennifer Shearer.
Jennifer Shearer. And Ms. Bourgeois Cooper, if you'll just kind of step just to the corner right there, closer, there you go. Ms. Shearer, you can come on up. Good morning, ma'am. Morning. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Yes. Thank you, ma'am. You may proceed.
Would you please state your full name for the court reporter?
From Marie Shear.
And Ms. Shearer, how are you employed?
I work at HEB and I'm with the Loss Prevention Department.
How long have you been with the Loss Prevention Department?
5 years.
And through your employment as a loss prevention officer with HEB, have you become familiar with the defendant Alexis Bourgeois Cooper?
Yes.
Please explain briefly to the court how you have come to be familiar with her.
She originally came on our radar back in February of 24 when she started stealing from our stores in Montgomery County. And then she was pulled over shortly after stealing at a Conroe store. And that's how we were able to ID her.
And you understand that she's already pled guilty today to a state jail felony level theft for $3,547 worth of cosmetics and makeup from a HEB store in Port Arthur. You understand that, correct?
That's correct.
And she committed that offense along with co-defendants Katira Green and Monique Wynn. Please briefly tell the court your familiarization with Katira Green and Monique Wynn.
Both of those parties are part of an organized retail crime and a spree group that we've been following about at the same time. And they have in Houston area, Katarina Green has for stealing from our stores about $56,000 worth of cosmetics, and then Monique.
Your Honor, I just object to any co-defendants' restitution amounts or what they've pled guilty to or found guilty of.
That's overruled. Go ahead.
And then Monique Wynn was about $42,000. And they're part of a ring that was hitting our area for a short period of time.
During the period of February the 24th through April the 24th, how many actual thefts did your investigation link to the defendant, Ms. Cooper?
10 events.
For a total loss of how much?
$8,956.50.
Now, for the entire ring, what approximate dollar amount would you put on? Well, let's break it down. What about for Wynn, defendant Wynn? How much would you attribute to her?
About $42,800.
And for the defendant Green, how much would you attribute to her?
$56,000.
Is it fair to say, in your opinion, that this group has been operating as an organized retail theft ring?
Yes.
And have you, in your 5 years of experience in loss prevention, have you, how would you rank this, this endeavor?
This is about the second highest rank we've had in HLE.
And you prepared a report?
Yes.
Okay, and you reviewed that report
That is
prior to testifying here today?
Yes.
All right, I'll pass the instruction.
Thank
No
you.
questions, Your Honor.
Thank you, ma'am. You can have a seat.
Judge, just if I may, I don't know what I was thinking today, that I agreed to a cap of 12 months. I certainly see how the court would be inclined to give this defendant more than 12 months, Judge. Well, actually, I do know what I was thinking. If you look at her criminal history, she actually has not been to prison before. She's got a number of misdemeanor thefts, at least theft arrests.
Not enough felonies that have actually been convicted and followed through that would get enhanced either. So, I mean, I could see my initial thought was the same. I wasn't quite sure where this came from. But I can see that it's not really enhanceable at this point based on any other felonies. So, Mr. Lane?
Well, Your Honor, obviously, we're asking the court to follow the agreement that was entered. The court does have the ability to sentence her to 12 months in the state jail. She did have a 1244 in Harris County that she did 10 months in the state, in the county jail. She does have a pending case out of Hidalgo County. What had happened back in 2019 and 2021 is her father and her grandmother died. And then she did get involved with these thefts. That was a major setback for her. She does have custody of 3 children. She is a phlebotomist and has some other skills that she can earn money with. So we're asking that you follow. She has a family law hearing that's the 24th of this month. We would ask you to sentence her to 10 months in the state jail.
Mr.
Coleman? We'd ask for the entire 12 months, Judge. Excuse me. I think she's benefiting from Mr. Lane.
Is that who is it? What is she?
She's benefiting from Mr. Lane's negotiation with me in working me down to a cap of 12. I'd ask for the entire 12, Judge.
Ms. Bourgeois Cooper, one of the things that stood out to me in your pre-sentence report, well, a couple of things. One, your criminal history is ridiculous. It's when I start having to turn page after page after page, that's a problem. And your version of this about I didn't really know what was going on, and I just went with somebody at the store, and I didn't know what county what I was in. You didn't know what county you were in because y'all were going from county to county to county, and still you're not going to help yourself by saying anything right now, okay? Because Ms. Shear was just here and has you on video at other stores doing the same things. So I don't dispute what she said under oath at all. I think Mr. Lane did an amazing job for you, and you are very lucky because he got you the cap of 12 months because you deserve a lot more, in my opinion. At this time, I'm going to find that you entered your plea of guilty freely and voluntarily. And in cause number 24 DCCR 1296, find sufficient evidence to find you guilty. And at this time, find you guilty of the state jail felony offense of theft of property. Sentence you to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lane. And all I can tell you, Ms. Bourgeois Cooper, is that I hope you learn your lesson while you're in state jail and stop all of the stealing, because each time you do it, this is only going to get worse. It's going to get enhanced. You're going to get more time. At this point, you now have, I think, 2 felony convictions, and that's going to start adding up. And you're going to end up with a lot more time and going to TDC instead of state jail. Do you understand? All right, and go back to the bailiff.
All right, friends, let's head back to Ohio and Judge O'Donnell, fresh contestant.
The State of Ohio versus Alonte Robinson, case number 26CR055. The defendant is present in the courtroom with his attorney, Mr. William Watson. We're before the court this morning for purposes of a change of plea in line with an agreement that's been reached between the parties. If it please the court, I'll put the terms of that agreement on the record right now. Thank you, Your Honor. Pursuant to the agreement, the defendant will plead guilty to count 1. It's a felony of the 5th degree obstructing official business. Also count 2, felony of the 4th degree assault. And count 5, felony of the 5th degree harassment of the bodily substance. With those guilty pleas being forthcoming after findings of guilt and at the time of sentencing, the state would dismiss all the remaining charges on the indictment. Part of the agreement, the defendant would agree to a restitution order in the amount of $1,582.92 for the body damage to the car into which the defendant pushed Officer McNamara. As to sentencing, the state would recommend an aggregate prison term. The defendant does not have to agree with that or join in that recommendation. The defendant could request any available sentence. It's my understanding that the defendant will request community control sanctions probation here. And this state would reserve the right to rescind or modify the agreement should the defendant violate a bond condition or be arrested for or charged with an offense while this matter is pending and prior to sentencing. Thank you, Your Honor.
Thank you. Mr. Watson.
Thank you, Your Honor. May it please the court, that's my understanding of this morning's hearing. This matter has been fully pre-tried with the prosecutor. I believe full discovery has been provided. I have had an opportunity to discuss this matter with Mr. Robinson. He is prepared to enter a change of plea as just outlined by the state. He understands that by entering a change of plea, he'll be waiving certain constitutional rights, and no threats or promises have been made in order for him to do so, Your Honor.
All right, thank you. Mr. Robinson, how old are you?
24.
How far did you go through school?
11th grade.
Are you a U.S. citizen?
Yes.
Are you able to read, write, and understand the English language?
Yes.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication within the last 48 hours?
No.
Have you ever been diagnosed with or treated for any mental illness?
No.
Did you get a copy of the indictment in this case?
Yes.
All right, it's been represented to me. You're going to plead guilty to count 1, obstructing official business, a felony 5, count 2, assault, a felony 4, count 5, harassment of the bodily substance, a felony 5, and agree to pay restitution in the amount of $1,582.92, and then at the time of sentencing, the rest of the charges will be dismissed. Is that your understanding?
Yes.
All right, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand a question, stop me. If you want to talk to Mr. Watson some more, let me know and I'll give you more time. You understand that?
Yes.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. You understand that right?
Yes.
Are you waiving that right?
Yeah. No.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you could be found guilty. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine those witnesses. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of these rights?
No, sir.
Do you still want to plead guilty to these charges?
Yes.
Do you understand by pleading guilty, you're fully admitting your guilt to the charges?
Yes.
You understand by pleading guilty to these felonies, you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
Yes.
In count one, obstructing official business, it's a felony of the 5th degree. It carries a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes.
Count two, assault is a felony 4, carries an 18-month maximum prison sentence and a $5,000 maximum fine. Do you understand that?
Yes.
Count 5, harassment with a bodily substance is a felony 5 with a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes.
Now, I could give you a consecutive sentence. That means one sentence after another for the separate offenses. If I did that, you face a maximum prison term of 42 months and a maximum fine of $10,000. Do you understand that?
Yes.
There's also an agreement that you would pay restitution in the amount of $1,582.92. Do you understand that?
Yes.
Are you currently on post-release control to the parole authority?
No.
You understand that if a prison term is imposed in this case, you might have to serve a period of post-release control for up to 2 years under the parole authority.
Yes.
If you are placed on post-release control and violate any conditions, the parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes.
If that violation is a new felony, then you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes.
If that were to occur, the maximum prison sentence for the violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes.
Do you understand if a prison term is imposed, you are eligible for judicial release?
Yes.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 42 months. Do you understand that?
Yes.
Has anybody promised you that I will be lenient on you just because you're pleading guilty today?
No.
Has anybody promised you what I will sentence you to in this case?
No.
Do you understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes.
Have you had enough time to talk to Mr. Watson before pleading guilty today?
Yes.
Has he discussed everything about your case and answered all of your questions?
Yes.
Are you satisfied with the advice he has given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes.
Do you have any questions at this point?
No, sir.
Mr. DePiero, if this case went to trial, what would the evidence show?
The evidence would show January 11, 2026 in Lake County, Ohio, the defendant, Alonte Robinson, was at the Skylight Inn in Willoughby. The police were called by a female, and that call was shut off in the middle of the call. So Lieutenant Grieg of the Willoughby Police Department responded to Skylight Inn to investigate, talk to the female. At this point, Lieutenant Grieg was investigating an assault and a theft charge, and that involved the defendant. He saw the defendant at the hotel. Lieutenant Grieg told the defendant to stop so Lieutenant Grieg could talk to him. The defendant would not stop, and Lieutenant Grieg grabbed the defendant's backpack, at which time the defendant pulled away, said, "Let him go." He said, "Let me go, I'm going to beat your ass." The defendant then ran off. He ran off into the street, actually, at Som Center Road in Maple Grove, where Officer Thomas McNamara of the Willoughby Hills Police Department, who responded to provide assistance, who was in uniform driving a marked cruiser, and he was a police officer in the performance of his duties, as was Lieutenant Grieg at this time. McNamara was in a cruiser, got out of his car. Officer McNamara told the defendant to stop and to put his hands behind his back. The defendant at that time grabbed Officer McNamara underneath his officer's bulletproof vest and slammed the body of Officer McNamara into a car that was parked at a red light at Som Center in Maple Grove, causing Officer McNamara injury to his back, a redness and soreness for days. Car drove off. Officer McNamara, the defendant, then came off of the car. When the car drove off, the defendant pushed Officer McNamara backwards. Officer McNamara tripped over the curb. The defendant was able to get away from the officer and ran. Other officers were in pursuit from Willoughby Police Department on foot and Willoughby Hills. The defendant went into Applebee's. The door was unlocked, but the store was closing, or the restaurant was closing. Officers observed the defendant inside. Officers went inside, including Lieutenant Greig, who ordered the defendant to put his hands behind his back, and he would not do so, would not comply with the orders. Lieutenant Greig then grabbed the defendant. The defendant grabbed the lieutenant. Other officers arrived, and the defendant was physically struggling with these officers. Officers could not get the defendant handcuffed because he was struggling. The defendant was also spitting, expelling saliva from his mouth at these police officers, including other officers who were on scene. Finally, the defendant was handcuffed and put in a cruiser.
Thank you. Mr. Watson, anything else to add to those facts?
No, Your Honor.
Mr. Robinson, did you hear what Mr. DePiero said, that the facts would show if the case went to a trial?
Yes.
Are those facts true?
Yes.
What is your plea to count 1, obstructing official business, a felony 5?
Guilty.
What is your plea to count 2, assault, a felony 4?
Guilty.
What is your plea to count 5, harassment with a bodily substance, a felony 5?
Guilty.
Mr. Watson?
This is the same form I went over with you, except this is the original. The photocopies there, but it's the same charges.
Are you here all day today?
I am, sir.
I gotta talk to you
I
about
need
that
you to
Kate
sign right
Mays
there,
situation.
and then put today's date. Today is March 17th, 3/17/26. And then sign your name right there.
The defendant, Mr. Watson, and I have signed the form. With the court's permission, I'm approaching to present that form to Your Honor.
Mr. Robinson, is this your signature on the written plea of guilty?
Yes.
Did you sign it voluntarily?
Yes.
Do you want me to accept your written plea of guilty?
Yes.
Accept the written plea of guilty. Defendant was present. Mr. Watson advised of all of his rights in a knowing, intelligent, voluntary waiver. He understands the nature of the charge, the consequence of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary. Will accept his plea of guilty. Find him guilty of count 1, obstructing official business, a felony 5, count 2, assault, a felony 4, count 5, harassment with a bodily substance, a felony 5. I'm going to refer this for a pre-sentence report and victim impact statement. Sentencing will be April 29 at 2 p.m. The bond is revoked. Anything else, Mr. DePiero?
No, Your Honor. Thank you.
Mr. Watson?
Nothing further, Your Honor.
All right.
All right, friends, let's head back to the great state of Texas, keeping this channel's promise with 9 to 11% more Judge Boyd. Here's Judge Boyd.
One point they're gonna ask if it's true or not true. Okay, if you look so fast, you're gonna, it's true. Okay.
All right, the court is calling 2024 CR 010476 and 2022 CR 6944, State versus Malik Estrada. Can I have parties announced?
Charles Blunt for Mr. Estrada.
And are you Mr. Estrada? All right. Did you review the motions to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it? Are you the same Malika Strada who was placed on deferred adjudication in 2022 CR 6944 for aggravated robbery on January 17, 2023 for a period of 7 years? And are you the Malika Strada who was placed on deferred adjudication in 2022 CR 6944 for the offense of, this is incorrect. All right, let's go off the record. All right, thank you. All right, we're back on the record. Are you the same Malika Strada who was placed on deferred adjudication in 2024 CR 010476 for the offense of unlawfully carrying a weapon with a felony conviction on October 17th, 2024 for a period of 5 years? Is that you? All right, state, are you proceeding on the same violations in each cause?
Judge, actually, we are going to be proceeding on the same violations for each cause. However, we're going to, in each case, withdraw and amend, and we're going to ask for a mental health evaluation, proof of employment, proof of residence within 45 days. And a weekly report.
Hold on, but first let him plead, he needs to plead true.
Yes, thank you. So are you all proceeding on the same
Yeah,
allegation
yes.
in each motion? All right,
Judge, we'll be going on violation case number 2, specifically that on or about the 11th day of April 2025 in Berry County, Texas, the defendant Malika Estrada did then and there failed to submit drug testing as directed by the court officer or supervision officer, and or duly authorized agent of the court in violation of commission number 2.
how do you plead to that?
True.
State,
And that will waive your remaining.
any objections to the waiver?
No.
All right, did you understand by pleading true to violation of condition number 2 and the cause number ending in 44, the court could find it true, grant the motion, find you guilty, sentence you up to life in prison and up to $10,000 fine? Sir, you need to have a seat. And did you understand by pleading true to violation of condition number 2 and the cause numbering ending in 76, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in the prison and up to $10,000 fine? Knowing that, do you still wish to plead true in each cause number? In each cause number, the court will find violation of condition number 2 true. All right, so the state has already said that they're asking not that the motion be withdrawn, but that conditions be altered and amended. So what I need to know from the parties, what are the issues? What's going on here?
Well, at the time of the number one that was waived, he was homeless at that time. That was about a year ago from now. Since then, he has a job, he has a residence, he has an automobile. After conferring with probation, the plan is for him to be evaluated for the mental health department. So see if he qualifies for their treatment, follow whatever recommendations they make. And he's going to provide proof of the employment and residency immediately, and then report weekly for 30 days. And that was the recommendation of probation.
All right. And state?
And we'll be following probation.
All right, thank you. No. All right, but I do have some questions for him.
Of course.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Malika Strada.
All right, so what's going on in your life? Why are you here before me?
At the time, I had just got out of lifetime recovery, and then I was working at Jack in the Box, and then so I didn't have a place to stay because they were asking a lot for where I was gonna stay at. So I went into an abandoned house just for the night to sleep, but I did have a job, and then I got enough to save up for a car, but then that's when my MTR hit. So then came back to this.
All right, so you don't have family support system?
Well, I have my she's like my sister, but my family is in El Paso, so I don't have anybody really out here, just her.
Do you need your probation transferred to El Paso?
That was a plan, but I didn't get to that.
Well, we're getting to it now. Because let me just tell you, probation is difficult, and it should be difficult because it's designed for rehabilitation. But sometimes people cannot make it on their own. They need a support system. The fact that you've been to lifetime recovery, the fact that probation is saying that there needs to be mental health evaluation, maybe you need a support system. Now, if your family is not a good support system, then maybe that's not where you should be. So that's what I'm trying to figure out.
Well, that's what I'm still trying to figure out as well.
Well, so do you want it transferred to El Paso?
The only reason I'm staying out here was because of my kids. So, but I wasn't really, I was really like just passing around as a kid. So like, they're not really a good support system. So.
Okay.
On his behalf, Judge, his residence is going to be with his sister here in San Antonio, so he can keep the job that he has and stay close to his children.
All right, so are you going to be able to do this successfully?
Yes, ma'am.
So you're saying you're stable now?
Yes, ma'am.
And do you still have, since you've been arrested, do you still have a place to stay?
Yes, ma'am. And I still have my car.
All right. All right, anything else?
Nothing further, Judge.
And so probation, you're asking for what specifically?
To provide proof of employment and residence within 45 days of release, either 40 or 30 days, a mental health evaluation, following recommendations.
All right. Other than what they're suggesting, is there anything else you need from the court?
I don't have to wait in here for that, correct? For the mental health evaluation.
Probation, do you want mental health evaluation in custody or out of custody?
Yeah.
All right, so this is what I'm going to tell you. I'm going to follow their recommendation, but the range of punishment on these offenses, I've already told you what the range of punishment is. So if there's another violation, you're looking at potentially 20 years in prison, potentially life in prison. Do you understand? All right, the court will follow the recommendation. This is what the court is going to add, though. The court is going to add parenting classes and proof of employment within 45 days of release, no employment as a home health care provider or with minors, weekly reporting for 30 days, and a mental health evaluation, and that can take place out of custody. Do not disappear. You must report. Do you understand? All right, and there's nothing else you need from the court? All right, thank you.
Thank you, Judge.
You're welcome.
Have a seat over here for me.
Cindy, do you need a cough drop?
All right, well, Judge hands out cough drops. Let's head a little bit east, go back to Louisiana.
All. Timothy, state your name and DLC number for the record.
Timothy Duval, 728417.
Okay, and who do we have with us today? Ma'am, please state your name and title.
Deputy Daniels.
Okay, Deputy, is there anything you need to tell us about him? Has he been okay since y'all have had him?
Yes, sir.
Okay, thank you, ma'am. Appreciate you having us today. All right, Timmy, did you sign a parole questionnaire? Do you have that with you?
Yes, sir.
Okay, you realize you're not eligible for appointed counsel. If you want counsel, you'd have to hire it.
Yes, sir.
Okay, you want to proceed today without appointed counsel?
Yes, sir.
Okay, I was assigned the case, Timothy, so I'll be reading your violations. You can plead guilty or not guilty with or without a statement. Okay, the first three pretty much deal with all the same thing. One of them is that you were supposed to report within 48 hours. One of them is that you're supposed to report by the 5th day of every month. You got to send a monthly report, and you got to live at the address stated. You did not live at the address of 316 Camille Street, Patterson, Louisiana, as stated on your GPS. You didn't report, you never reported, and you didn't contact your probation officer. How do you plead to those charges?
Guilty.
Okay, tell me why you didn't contact him.
I was in New Orleans and they had, I believe it's 2 days to go and talk to him, and I wasn't able to do it because I was in New Orleans. I'm homeless, so I don't have a car, and I tried to hitchhike back to New Iberia, but I didn't make it in time. That's when I first got out. That's why I wasn't able to report it in the 48 hours. I thought that's the only bus ticket they had.
Did you ever call in to talk to your officer or ask them who your officer was?
I sure didn't. I should.
Okay, well, at least you're honest. I appreciate your honesty. Okay, and your other charge is I will not engage in criminal activity, nor will I associate with people who are known to be involved in criminal activity. And I will avoid bars and casinos and refrain from drugs and alcohol. You engaged in criminal activity on 12/29/25 when you were arrested by the Patterson Police Department and charged with theft misdemeanor and resisting an officer misdemeanor. Subsequently, those charges are still pending. How do you plead to that charge?
Guilty.
Okay, have you went to court on them yet?
No, sir.
And condition number 10 is you pay your supervision fees of $504. Have you made any payments on your supervision fees?
No, sir.
Okay, so. My colleagues have any questions? I have no questions.
No question.
I have no straightforward. Okay, Mr. Duval, you've been straightforward. You have pled guilty to all your violations. Your closure date is 12/1/26. I find you in violations of conditions number 1, 2, 3, 4, and 10, and order that your parole be revoked. Mr. Power?
I concur, same reasons.
And Mr. Tiller?
I concur, same reasons also.
Okay, Mr. Duval, good luck to you. Like I say, your closure date's in 6 months, so, well, 8 months. So, take care of your charges and when you get out, make sure you report, okay?
Okay.
All right, man. Good luck.
It's just been revoked. I think that's how Peter Griffin said it. Sounds right. Anyways, back to Judge West.
Good morning. Are you Matthew Smith? And Mr. Smith, I need you to speak up, please. So I can hear you, and so the court reporter can hear you, okay?
Yes, ma'am.
Thank you. Mr. Parker, will your client waive the reading of the indictment?
It will, Your Honor.
Mr. Smith, in clause number 26, DCCR 0073, you're charged with the state jail felony offense of theft of material, copper, and that's from December 8th of 2025. And how do you plead to that charge?
Guilty, Your Honor.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, Your Honor.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, Your Honor.
And it looks like the agreement that you've reached is for a 5-year deferred probation. Is there a fine?
There's not a fine, but it's supposed to be restitution, which I don't know. We didn't have.
So there will be restitution that will be determined for sentencing?
The owner has never turned in a restitution, Your Honor.
Okay.
This is copper from a business.
Right.
There might have been insurance coverage, but there's never been a form turned in by the owner.
So would you want to waive PSI and go forward, or do you want me to set it for a PSI with restitution to be determined so that if there is some, they can get that to y'all before sentence?
Well, PSI would be good. Thank
So
you, Judge.
if If there's any restitution, then you would be ordered to pay whatever that amount is. Do you understand? As part of your probation?
Yes, Your Honor.
Do you also understand if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, Your Honor.
State tenders number one.
Objection?
It's admitted. Is there any evidence that Mr. Smith is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do that pre-sentence report and see if there's any restitution that they can determine between now and then we'll come back later for sentencing. Ms. French, what is the state's position with regard to me reducing the bond based on the nature of that plea agreement for sentencing?
It's 30 days, Your Honor. Whatever time he gets, he'll get credit for.
Well, if it's a
Probation is a
if it's a deferred probation, typically just, so
Oh,
you
I'm
haven't been in
sorry.
here.
I'm so sorry. I was thinking of another 12-month term.
Yeah, it's
Moving on to the next one. Sorry. I'll defer to the court.
no issues that you see me doing that. So, Mr. Smith, what I'm going to do based on the nature of your plea agreement is reduce your bond to $1,000, but I'm going to make that a personal bond. And so what that means is you're not going to have to pay the $1,000 to get out of jail. You're just going to get out of jail today. But there's some very important things about that. The first is that the first thing you do when you get out of jail is go to the probation department so they can start that process to do that report. If you don't do that, then you run the risk of me not accepting the plea agreement and things could be worse. Do you understand?
Yes, Your Honor.
Also, if you're arrested for anything between now and when you come back for sentencing, you obviously run the risk of me not accepting the plea agreement and things would be worse. Do you understand that as well?
Yes, Your Honor.
All right, then we'll see you back at sentencing. Probation is going to give you some paperwork in just a minute so that you know exactly where to go when you're released today, okay? All right, you can go back with the bailiff. Mr. Radford on Floyd Torrin.
Yes, ma'am, it's a plea. He signed up.
I've got it, Floyd Torrin.
It's
And are we on both?
Yes, ma'am, we're pleading on both. It's
Okay.
counts 1 and 2. Abandoned the habituals. I have some letters and some documents I would like to submit and send them to supplement the PSS. Go ahead and need you to sign this and I'll to you.
Oh, okay, there was an amendment to the indictment. Change to.
Do you want me to email? I'm just going on council now too.
Thank you. Good morning, sir. Are you Floyd Torrin?
Yes, ma'am.
And Mr. Radford, will your client waive the formal reading of the indictment in each case?
Yes, ma'am, he will.
Mr. Torrin, in clause number 25, DCCR 0794, you're charged with a third-degree felony offense of attempt to commit theft or property from an ATM, and that's from May 10th of 2025. The indictment alleges in count 2 that you were convicted of the felony of possession of a controlled substance, a second-degree felony, August 16th of 1999. How do you plead to that charge?
Guilty.
And is that prior conviction true? Did you enter your pleas of guilty and freely and voluntarily? And did you plead guilty because you actually did what they charged you with? All right, give me just a second and I'll get that. The efficiency of going is. All right, then, Mr. Torrent, in cause number 25 DCCR 1152, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from June 20th of 2025. The indictment alleges the same prior conviction of possession of a controlled substance in count 2. And how do you plead to that charge? And again, is that prior conviction true? Did you enter your plea of guilty and true in this case freely and voluntarily, and because you did what they've charged you with? Each of these cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Radford? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached in each of these cases is that, the agreement was that the state allowed you to plead only on counts 1 and 2. And that your punishment is the full range of punishment, which is a second-degree felony between 2 years and up to 20 years up to the court. Knowing that had you gone on the full indictment, you would be looking at a habitual status, which is 25 to life. Is that your understanding of your agreement? I want to make sure you understand you have every right to have a jury come in and determine 2 things. 1, if you're guilty or not, and then you could leave your punishment up to that jury. If we go forward this way, you're waiving that right and you're leaving it up to me, and also waiving your right to appeal as long as I stay within that 2 to 20 range. Do you understand? And is that what you want to do? Do you also understand, sir, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objections.
It's admitted in each case. Is there any evidence that Mr. Torrent is not competent?
No, ma'am.
All right, sir. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Also find that you entered those pleas of true to counts 2 freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to reset your cases so that the probation department can do a pre-sentence report. That'll give me more information about you, your cases, and then we'll come back later for sentencing. Anything that you think is important for me to know, be sure and get that information to Mr. Radford, and he'll get it to me so that I can review, and he'll present more, whatever, that day when we come back for sentencing. All right?
Judge, I'm gonna have some documents I will present.
Thank you.
I will
Thank you.
email them to the clerk and CC Mr. Smith.
Okay, make sure you get them to probation, and they'll attach them with the PSI as well.
Yes, ma'am.
All right, thank you. You can go back with the bailiff.
May I be excused?
Yes, sir. Mr. Rojas? Yes, I know. Brenda Sanchez, Mr. Himmler, Brenda Sanchez.
Thank you.
Very educated, I wasn't hired on trade.
Okay,
I'm got to go on what you said. I told Mr. everything. He doesn't want to listen to you. That's somebody else's.
so are we here on a bond?
She's on straight probation and it's picked up a new case. I say new case, it's 2 years old.
Mr. Kimler's filed a motion to quash the indictment.
For pre-indictment delay, but
It's filed within the statute.
it's within the statute of limitations.
So what's the,
Well,
basis?
there's a due process right to timely indictment. There was just a due delay in the indictment, even though it's within the statute. Period.
Good morning. Are you Brenda Sanchez?
Yes, ma'am.
This is cause numbers 26 DCCR 0027. And then Ms. Sanchez, that's a new case of a possession of a controlled substance. And then the Ms. Sanchez is on probation, and cause numbers 20-33832 and 20-33. I'm sorry, 20-34508. Both of those for theft of property cases.
Yes, ma'am.
And so what are we here for today?
Well, Your Honor, we would request a hearing on the MTRP for them to try to prove up the new case. I think she's performed satisfactory as far as administrative.
So if there's no agreement, we just need to go through the motions?
Well, yes, ma'am.
Okay. Ms. Sanchez, lift your hand, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. You can put your hand down. Will she waive the formal reading of the motions in each of the cases?
So,
Ms. Sanchez, in cause number 20-33832, I have a motion to revoke your community supervision. Shows that you were placed on probation February 22nd of 2021 for the offense of felony theft that had been enhanced to a third-degree felony, and that was a 10-year term in prison that was probated for 5 years. Is that correct?
Yes, ma'am.
Just a second. All right, I'm there. And then in cause number 20-34508. I also have a motion to revoke your community supervision. It shows that you were placed on probation February 22nd of 2021 for the state jail felony offense of felony theft that was enhanced to a third degree. That was also a 10-year term in prison that was probated for 5 years. Is that correct? Each of these motions allege that you violated your probation. Count 1 in each motion alleges that you committed the new offense of possession of a controlled substance, penalty group 1, in an amount of between 4 grams and up to 200 grams, August 15th of 2024 in Jefferson County, Texas. And is that true or not true?
No, ma'am.
True or not true?
Well,
I just need you to say the word, true or
not
not true.
Not true.
Thank you. And then count 2 alleges in each case that you failed to avoid persons or places of disreputable or harmful character, specifically by failing to avoid presence at a location where a criminal act was being committed, by residing at a location identified by the Beaumont Police Department as a narcotics stash and distribution location. And is that true or not true?
Not true.
Count 3 in each case alleges that you possessed a controlled substance, namely Dilaudid or hydromorphone, without a prescription, August 15th of 2024. And is that true or not true?
True.
that is true.
Well, I mean, on possession, but it was my friend's medication that was at my house.
Count 4 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true?
Not true.
All right, so I'm going to show that you entered a plea of true to count 3. Did you plead true to count 3 freely and voluntarily?
Yes.
Okay, so I'm going to find that count true, find sufficient evidence to revoke your probation. However, I'm going to reset your case so that the probation department can do an updated report. We'll get it set for a hearing. The state intends to bring witnesses with regard to the new offense.
Yes, Judge, yes. Should take care of me. And it shouldn't take very long. I know. On the heels of yesterday.
I'm a little gun shy on that, Mr.
Yesterday.
Coleman. We'll set it, an 11 o'clock hearing. I'm talking, Mr. Kimler. So I'll set it at an 11 o'clock hearing. And here's the important thing, Mr. Kimler, as we've talked about before. If there's something that comes up and there's some change in status of her pleading true or not true without the necessity of a hearing, please let Mr. Coleman know that. I don't want officers showing up here and wasting their time, and then all of a sudden there's a deal made at the last minute, okay?
Suspect that, Your Honor, but I do think that as far as possession goes, I understand the circumstances that she's explained them to me. I don't want any kind of perception by the court that she's misrepresenting things, but it may be better that I change that to not true.
Yes, sir.
On 3.
Okay. So there will be,
There's
please
an
and not true. It's all right. We'll
there's
get to
an
that.
explanation for that.
Please and not true on all of the counts. State will bring witnesses on those and we'll get it set for a hearing. We'll get an updated pre-sentence report. Obviously, Ms. Sanchez, anything that you think is important for me to know, get that information to Mr. Kimler. He'll present it to me on your behalf when we come for the hearing. You can go back with the bail. Oh, wait. We need a fingerprint.
We can back to talk.
All right, we've been bouncing around the South for quite a little bit. Let's head back up north and go back to Judge McNally for a while.
I see what happened. This is the one they brought to me yesterday, right?
That's correct.
Default judgment set aside. Effective right now, Heather. And then you're gonna plead to limited access, right? 5 over?
Yes.
And you're authorized to center that plea on behalf of the client? All right, out to that charge, 5 over, limited access, 75 and 70, responsible or not responsible?
Responsible.
What's her record like?
Pretty good. She's commuting to University of Toledo Law School, so she's got
Going to law school?
Yeah, she's there now. That's why I'm here. So I already went.
You went to Toledo?
No, but law school. I guess I put on my necktie. Go within her.
All right. Okay. Well, let's see here. I'll make it 165. And then we'll refund the balance, okay? So Heather, we're gonna keep 165 for fines. And then you can refund the balance to Ms. Raybon. She posted 225 because it was a default. Okay?
Thank you, Judge.
Have a good day. Thank you. Tell her to study hard.
You're welcome.
Randy Moore, Jr. Randy Franklin Moore, Jr., 26W841532.
He's on Zoom.
I'm
Judge.
sorry, Amelia Moore. Somebody wrote Randy Moore.
We did that.
We did Amelia Moore.
We have a Randy Moore.
Why do I have both of these in the same file? Did I do that? All right. John,
Yes, sir.
do you have a Amelia Moore over there? I don't know why they both ended up in this file.
It's Randy Moore.
That's the
Randy
problem.
Moore, and Randy Moore should have 2 files, Judge, a department rep, and I brought down a warrant that had a balance on it.
What is going on? I got Randy Moore files. I got Amelia Moore register.
That's all I got there.
I got another. What is Amelia Moore? I don't know. Did we do Amelia Moore?
We did, Judge. You just did her for impeding.
Yeah, I don't know why I have her register in this other file. You got to find that one, John. Okay, Randy Franklin Moore Jr. What is going on here? I have no idea what's going on. I had Amelia Moore in front of me.
Yeah, I just,
Give me that.
is that a flat room case?
Well, somebody put something in the wrong file, one of these
Is
guys.
that flat room?
This is Woodhaven.
Let me call over here, so I don't have.
Hang on. So I gotta redo this. Hang on. So I just want to be sure on this, Heather. Amelia Moore pled to impeding on file 26W84131. I gave her, she's to pay 75 by April 10th and the balance by May the 10th. Is that true?
That's correct, Judge.
I got another Randy Moore file here. They put him in the wrong register, one of the officers, I think. So this is the speed charge. And this is going to be a plea to impeding. All right, Randy Moore Jr., 26W841532. Your name?
Randy Moore.
Hang on. This is crazy. All right, you're going to plead to impeding, right, sir?
Yes, sir.
To that charge, responsible or not responsible?
Responsible?
I'll accept the plea, but you got a warrant. Why haven't you taken care of this other case?
I didn't even know that it was there, sir.
been here
I thought
since
that fine had
2020.
been paid completely.
I'm sorry?
I thought that fine had already been paid completely.
It wasn't. We would have sent you multiple notices. Where are you at now?
I'm the same place. I live in Ohio. Lorain, Ohio. I've never received anything from anyone up there.
We don't keep secrets over here. We would have sent you notices, okay? Multiple
Yep.
notices you would receive back in 22. On this one, I'm charging you $160. On the other one, and I'm gonna expect you to pay that today, as well as the one that you have a warrant out on. Do I have that file, John?
Should be in there.
What the hell is going on this street? You're 182 on this other case. It's in front of Judge Hudson. It's from 2021, 21W828-719. So you're gonna pay this too, right?
Yes, sir, I can. I would have to break it up into payments though, because I don't have that much right now because I'm not driving anymore. I'm doing a dispatcher and it was a little pay cut. Get most of it probably taken care of on Thursday when I get paid.
I don't like this. Can you pay the 182 on the 21 case by Thursday?
Yes, sir, I can do that.
You pay that in full or else we're gonna show cause you. You pay
Yes,
it in
sir.
full. Pay it in full by March the 19th. The other one I can give you time on.
Thank
So
you.
so on the other one, I'll give you how long do you need?
Probably until maybe the second week of next month.
I'll just make it April the 13th. If you need more time on that, you call the court. We'll go on Zoom. I'll give you an extension, but don't ignore us again, okay?
Yes, sir, absolutely.
You understand everything?
Yes, sir.
All right, good luck. Thanks.
Thank you.
Alan Robertson. 26T647-824. Your name, sir? All right. 1 second here. All right, you're gonna plead to impeding traffic, right?
Yes, sir.
To that charge, responsible or not responsible?
Responsible.
Okay, I'm gonna accept that plea. I'm going to dismiss the speed. And you got a good record. 150 is your total, okay? Have a good day. Thank you. Right down to the cashier, Aubrey Brown, 26T647-838. Good morning. Your name? You're gonna do impeding, right? Responsible or not responsible to that? So what are you still in high school or?
Yeah.
Where at? Okay, what are we doing next year?
Going.
Where? Good for you. Good luck. I'll accept your plea, 150, cashier under the hall. Good luck. Thank you. John Sharks. 26T647-837. Your name? You want an informal?
Please.
He's offering you impeding.
Got a great driving record.
If everybody, listen, I'm just telling you, they're not gonna change it to a warning. And I can't change it to a warning. If you want to come and have a hearing, I have no problem with that. But if you're convicted of just going 5 over, you're gonna end up with a point on your record. Okay. All right, good enough. We'll set an informal hearing. This is Sergeant Neats.
We could do March 31st at 9:30.
March 31st at 9:30. You go down there. Pardon?
That'll be fine.
You can go down the hall and they'll give you a notice, okay? We'll see you back here. Thank you. Olivia Rose Jeanette Fussell. 26T647-823. Good morning. Your name? All right, so you're gonna plead to impeding, right? Responsible or not responsible to this? All right, I'll accept your plea. Fines cost 150. You can go down the hall and take care of that. Good luck. Thank you. All right, Brian Shane Griner. 25B1496788A. B. 25B149713A, B, and C. Your name?
Brian Griner.
You have 3 show causes here on civil infractions. You also have a driving on a suspended charge from November of 25. You also have a leave the scene of a property damage accident, same date, November 15 of 25. When you were issued those citations, you were issued 3 other civil infractions. Expired plate, no proof of insurance, and driving left of center. You're in default on all of those. You have the right to a lawyer. I'll be happy to arraign you and give you a lawyer if you would like one. Would you like one?
Yes, Your Honor.
Where you been?
I've been sick, I had abscess and I got a broken back and I just been dealing with that. Work's been slow.
Judge, did he not meet, his file should have gone to the MIDC attorney already. Did he not meet with him?
Did you meet with a lawyer yet?
Yes.
Who'd you meet with? What do you look like?
It was chunky.
Well, let's get Mr. Shemke in here. Have a seat right back there. I didn't know you'd seen him yet. Eric Williams, 26W841670. Good morning, sir. Your name?
What?
You're gonna plead to impeding traffic, right?
Yeah.
Okay, commercial vehicle, responsible or not responsible to that? All right. 180 is your total. You're all set. Have a good day. I'm dismissing the speeding. Can't be in another courtroom, is he?
I just saw the text, so I said.
Anthony Panuto. 260-647-854. Your name?
Anthony Schmudo?
All right, you're going to plead to impeding traffic, true?
Yes, sir.
Responsible or not responsible to that?
Responsible.
I'll accept the plea. 160 is your total. You can go right down the end of the hall. Have a great day. Why don't you go get your lawyer, Mr. Griner? Tell him I'm ready. Carlos Calderon. 260-647-702. Good morning. Your name?
Hold
All right, you're gonna plead to impeding traffic, right? Responsible or not responsible to that?
Responsible.
You got no entries, 150 is your total, you're all set.
Yeah.
Speed's dismissed, you too. Stephanie Nicole Elliott. 26F245760. I don't know what this means. Your name?
What was that?
Your name?
Stephanie Nicole.
I don't know what this means. Provided proof of registration renewal.
I was driving on the expired tank.
Yeah, I get it. So what is he gonna do with this? Whose is this? Flat Rock? I need to know what they're gonna do with that.
I don't know what that is.
They didn't write it down. Have a seat right at the table there, okay? Right behind you. I'm gonna need Flat Rock's department rep to tell me if there's a plea or what he's doing with that.
Okay.
Brian Sheen Griner, 25B149713A, B, and C, and also I have 25B1496788 and B.
Good morning, I'm Mr. Chip. My client stands my name up.
Your name, sir?
Brian Griner.
All right, so what is he doing on the misdemeanors? Drive off, suspend, and leave the scene.
We wait for more reading my client stands meeting.
All right, I'm gonna enter a not guilty plea for those. Where's he been?
Your Honor, he's apologized for not coming in earlier. He has severe back pain. He had a severe back injury. I believe he broke his back and he was debilitated at the time. He also was experiencing severe illness, but he did indicate that he walked it. He did not drive here, Judge. His stepfather drove him. He's got a strong family support system living in Monroe. And when he can, he does independent contracting work. He's apologetic for not taking care of this earlier.
Why didn't you at least call the court? We could have done this on Zoom.
Just found out about the special one yesterday, that's why I'm here today.
I know, but you got the tickets back in November, right?
The acting happened in November, I didn't get the tickets till about a month later.
Yeah, so you know, well, says,
Money to pay them, I just,
all right, I'm gonna give you a personal bond, $500. You cannot leave the state without consent of the court or violate a law, even if the hearing court is directed. I'm entering a not guilty plea. I'm entering a plea of denial on the, I'm sorry, I'm entering pleas of not guilty on all of these. We'll adjourn the show cause hearings, Heather, to the date that I set the pretrial on. Can you afford your own lawyer?
no, Your Honor.
So if you want a court-appointed lawyer going forward, you're gonna have to fill out a petition for one, okay? All right, Heather, why don't you give me the dates? Or you
There
got
should
it on
be.
here, don't you?
Yes, there
sorry.
should be a sheet.
My fault. March the 25th at 10:30, okay? March the 25th at 10:30. So he'll hand you a petition for a court-appointed lawyer. You fill it out. Remind John when he comes back, if you would, Heather. I'm sorry, Sadie. And John, he needs a court appointed. Then once you fill that out, hand it back to him, go down the hall, get your notice, and we'll see you back here on that date. Do you have any questions? Okay. Good luck.
This guy here?
Yes.
Thank you, Judge.
Thank you.
Thank you, everybody.
You too. So don't go anywhere until you fill out that petition, okay? I'm not writing on all these other, maybe I'll,
It's all right, Judge. I'm putting all the dates in right now.
thanks. Do I have Logan Scott Davis here? Did you meet with a lawyer yet? Come on up here. Logan Scott Davis, 25W839-209A. Your name?
Logan Scott Davis.
You're charged with violations of probation. No, I just wondered if he's gonna dismiss or is she gonna plead? Oh, I see. Okay, I see. Okay, thank you. Thank you.
There should be two of them.
Okay, Mr. Davis, you're charged with 3 violations of probation. I'm gonna arraign you. Actually, you have 4. I'm gonna go ahead and arraign you on these charges. I placed you on probation, it looks like. Boy, you're not taking me very seriously, are you?
I just haven't had a vehicle, Your Honor.
Nah. You're charged with failure to pay fines and costs, balance owing $1,075. That's count 1. You understand the charge? Count 2, you fail to provide proof of completing 24 hours of community service. Do you understand the charge?
Yes, Your Honor.
Count 3, you fail to provide proof of attending 12-step meetings weekly. Do you understand the charge?
Yes, sir.
Count 4, you failed to provide proof of attending and completing outpatient treatment. You understand the charge?
Yes,
If you plead guilty, if you're found guilty, that would be violations. Your probation could be revoked. You could be incarcerated for 93 days. Do you understand that?
yes, Your Honor.
You're presumed innocent. They have to prove you guilty by a preponderance of the evidence. You have the right to a hearing. At a hearing, you can question witnesses, bring in your own, use the subpoena powers of the court to bring in those witnesses. By pleading guilty, you're going to be giving up all those rights, and we are not going to have a hearing of any kind. You understand that? All right, so you have the right to a lawyer. Be happy to provide you with one to pay at public expense if you cannot afford one. Would you like a lawyer?
Yes, Your Honor.
Okay? I'm going to enter a not guilty plea for you on these. So we will set you up. You will talk with the lawyer, and then you'll come back in front of me, okay? Who needs a lawyer there, John? Pardon? So you go right out in the hallway and we'll set you up. Stephanie Nicole Elliott, 260F245760. All right, I see what he was doing. Your name? Nice and loud for me. You're gonna plead the expired plate, right?
Yeah.
to that charge, responsible or not responsible? When did you get your proof of registration?
That following Monday, it was a Friday, I got it.
Okay. So you were expired, man. All right, I can cut it down for you, $85, okay? You weren't that far out of date. You can go down the hall and take care of that and you're all set. Best of luck. Melvin McGee Jr. 26WH41451. Could I have seated up here at the tables, please? Melanie Meyer, Hadley Sanders, and Tiffany Stannis. Your name, sir?
No.
You're going to plead to impeding, right?
Correct.
I can't in good conscience take this. There's no way. I'm sorry. You can either plead as charged or you can go to hearing. You got 6 violations on your record here. So you can either plead as charged or you can set an informal, whatever you'd like.
Okay, points on the license, where go down?
I'm sorry,
Are the points for the decision?
1. To the charge 50 and a 45, you plead responsible or not responsible.
That was one.
I'm sorry, I just can't do this. 135 is your total. You're all set right down the end of the hall. Good luck.
Could I have to, I get paid once a month? I get paid, my next pay is on April 3rd, that first Friday.
I'll give you till April 6th, okay? We're actually closed on the 3rd, or at least, yeah. Got to slow down. Okay, I don't know how they sent this in to me. They know I wouldn't take that.
No, it's a recall on the vehicle. I have a letter from GM, because my dash literally goes out, so I gotta take it and get that correction. I have the letter with me, but I just mailed it out to January.
Sorry. There's nothing I'm gonna do on that. There's just, you can't keep driving, speeding like that. I'm sorry. Good luck.
Bye.
Melanie Meyer, 26T.
It's TCF Live. It's St. Patrick's Day. About a half an hour to go yet for the show. I don't know if you guys are feeling the luck of the Irish today. I'm not sure I am. It's been weird. I just encountered the strangest YouTube error I have ever seen. So, little behind the scenes real quick. When you upload a video, if you're doing it right, you upload it and then you leave it unlisted and let YouTube run its checks on it to make sure there's no issues. And then you go and you attach the title and the description and the thumbnail and all that. I had all that set up for a Judge West video that is already live for channel members and goes live for everybody in about an hour and a half. And YouTube just stripped all of that out. It took away my title, my description, my thumbnail, just like they never existed. I have never seen that in all the time I have been doing YouTube. That's a new one. But it really gives you confidence in the platform as a creator, I'll tell you that much. Something new every day. But speaking of Judge West, let's go back there.
It's a burglary of a habitation from April 29th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? Speak up, please. Thank you. I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Sneed is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Mr. Nichols, what's
His criminal history is very limited, Your Honor. I have no objection to a bond pending sentencing.
Okay, and so, Mr. Sneed, what I'm going to do based on the nature of your plea is reduce your bond to $1,000. I'm gonna make, a condition of that bond, is that if you cannot have any contact or be around or go to, the habitation of Billy Davis, what is that address?
595 Ashley.
2595 Ashley. So you cannot go anywhere near that location, okay? That's part of your bond if you make it. If you make your bond, then it's very, one of the first things you do is go to probation so they can start that report. If you don't do that, then you run the risk of me not accepting the plea agreement and things could be worse. If you're arrested for anything between the time you make bond and come back for sentencing, obviously I don't have to accept the agreement and things could be worse. And then finally, if you violate that condition of your bond and have any contact with or are around the address that I just stated, then you obviously run the risk of me not accepting the agreement. Do you understand? All right, we'll see. Yes,
I'm
ma'am.
sorry. Mr. Sneed wanted me to ask if the court would consider a personal recognizance.
At this point, because of the nature of the offense, I want to make sure that there is some bondsman. It's as low as I can make it at 1,000, so that if he makes that bond, at least there's someone making sure those conditions are being followed based on the nature of the offense. Okay. All right, you can go back with the bailiff.
Thank you, Your Honor.
Thank you.
All right, I did the math. We're only at about 7% more Judge Boyd today, and our channel promise is 9 to 11. So let's go back there and try to tighten that up.
Print it out if you need them.
Oh, they've given me the motion.
Okay, Judge.
So there's two motions.
There's a UUMV and an ag rob, Judge.
All right. I don't have the 2-6.
Okay, here's 2-6.
Thank you.
Do you have the attachments, Judge?
No, I do not.
Okay, I'll.
What's the cause number on this one?
It is 2026 CR 000424 and 426.
Okay.
And then here's my attachment. It's the letter thing that they've secured of work for him in the month of March, and they can.
Oh, yeah, urban funds.
Yeah. Okay.
No problem.
All right. So,
And then you should get the attachments, or this is the.
thank you. So State, are you going to have any objection to that, to his working?
Sergeant?
He's asking that the bond be, that the conditions of bond be amended to allow him to work.
And Judge, we're gonna object to any kind of amendment or changes to the bond conditions because of the nature of the charge.
All right, court is calling 2026 CR 000424 and 2026 CR 000426, State versus Jose Salazar. Can I have parties? Thank you. Announced for the record.
Brandon Prater for the state.
Robert Ariano for the defendants.
And are you Mr. Salazar?
Yes.
All right, defense has filed a motion to modify conditions of bond, and it's the court's understanding, State, you are in objection.
Yes, Judge, we're in objection.
All right, defense, you may proceed.
Thank you, Judge. Just a little bit of background. I know you have the motion in front of you, but the defendant's charged with ag rob and UUMV. This offense occurred about 10/29/25. He was released on January 7th, 2026. The bond was modified from 45,000 and modified to 45,000 and $5,000 on both cases, and with the conditions of full house arrest with GPS monitoring. The defendant, we are requesting that he be allowed to modify his full house arrest to tracking I guess no house arrest, and the GPS be tracking only to allow him to go to jobs that have been set up with a group called Urban Apostles. I've attached letterhead from this group, this organization. They have set up multiple jobs for Ismael with regard to catering services, all kinds of jobs, but they have a schedule set up for the month of March. I know we're almost done with the month of March, but this is an established organization that works with juveniles and young people. My client is 17 years old. He's living at home right now with his mother. The reason that we need him to work is just to get him back out, start working a job again, and help his mother with finances because of the situation. She is about
My
to.
question.
Go ahead. Yes, Judge.
So you say they have a schedule, and this schedule that they make, it's a monthly schedule.
Yes, Judge, correct.
So he will have his schedule will be set for the month of March, the month of April. People will know where he is and the hours. Because what I can tell you,
Oh, God.
I am only I'll allow him to work, but he will need to provide hours. I'm not going to do tracking. He'll be allowed to work, but he's going to have to provide his schedule uh, to GPS
Understood.
pretrial. And again, he's not to have any contact with any of the complainants.
Yes, Judge.
All right.
Yes, Judge, we can provide those hours ahead of time to his pretrial services officer to let him know, let him or her know his hours ahead of time so that he can be allowed to work.
So when would he know his schedule?
So with regard to the opportunities provided, I don't think he'll know the schedule immediately, but he will know it as soon as they know that he can work. Then his liaison, the gentleman who did the letterhead, he can send me his hours, whatever job they set him up with. Because what they sent me was a list of jobs that are available for the month of March that Ismail could work at.
All right, so this is what the court is going to order. The court will order partial GPS, and you are to provide the work location and the hours within 48 hours.
48 hours before he goes to work, he needs to provide. So if he has a job on Monday of next week, he needs to provide that on Friday, like, more or less. Is that right?
Yes.
Okay.
But if it is a case where you say they have a monthly schedule all worked out, then he'll provide his schedule for that full month and say, here's my schedule. But what I can tell you is if you're supposed to be at location A and it turns out you're not at A, you're at C or D, they're going to issue a warrant. Do you understand? All right, is there anything else?
I think for the defense, Judge.
Thank you.
Thank you, Judge. With regards to when you start, do I have to take it to the back, or are y'all?
Oh, I'm signing it right now and then you can get a
Okay.
copy. All right.
And that's for
thank you.
2024 and 2026. For both? Okay.
Yes.
Just making sure, Judge.
All right, no
All right,
problem.
thank you, Judge. May I be excused?
Yes.
All right, thank you.
Alrighty, just looking at the time left and trying to calculate the next best move. Let's try the board one more time. What are we? I think we're 1-1 on the board today, so let's break that tie.
Okay, please state your name and DLC number for the record.
Oh, Brian Bradstreet, 737-019.
Okay, and is there anyone in the room with you or they left?
They gone.
Okay, that's okay. Okay, did you get a parole questionnaire, Mr. Bradstreet?
Yes, sir.
Okay, do you realize you're not eligible for appointed counsel? If you want a counsel, you would have to hire it?
Yes, sir.
Okay, so you want to proceed with the hearing today without appointed counsel?
Yes, sir.
Okay, your case has been assigned to Mr. Tillis. He'll read your violations and you plead guilty, not guilty with or without a statement.
Good morning, Mr. Bradstreet. How are you?
I'm all right, sir. Good morning.
Good. On 12/18/2025, the offender was arrested by the probations and parole for the NOPD warrant, domestic abuse battery. Pending charges, case number M624152 on 117. The state refused the charges. How do you plead? Guilty, not guilty, or with a statement?
I plead not guilty with a statement.
What happened? Tell us what happened.
I had been in a relationship. I was in a relationship, and the female that I was with, she ended up cheating on me. So I left the relationship alone. So prior to me leaving the relationship, she said that I hit her, I gave her a black eye, and I broke her phone, but none of it didn't happen. The black eye came from her having a fight prior to me and her having an argument. All we had was a simple argument. It never went to no farther than me hitting or breaking her phone and none of that. I left and went by my business. That's the only, ain't nothing more to the story, Mr. Tillman.
How did the phone get broken?
The phone never was broken.
The phone that, I'm
Hang on,
sorry.
get to you, ma'am.
The phone never was broken. The phone that they never hold no. They never gave me a. They never said that what the phone held, like the charge of the phone. Like they never charged me for how much it cost or nothing. The phone never was broken. They don't have a picture of a broken phone. They don't have the amount due to get the phone fixed or nothing. The phone never was broken. All of it was falsified. It was a lie.
What was the argument about the phone? We're trying to get her to show you her phone.
I had the phone in my possession and I went through the phone. After I went through the phone and seen she was cheating, I gave her phone back. When she seen that I was leaving, it was a problem because we was breaking up and she did not want to let me leave. So only the problem was is that I felt like she didn't want to see me with the next person I was going to go to, or whatever the cause may be. So I just left. I never.
Did you hit her?
No, sir. I did not hit her. Did not put my hands on her, nothing. I left.
Okay. My colleagues have any questions?
Let's hear from the speaker in this, because I think she could help try to clear up some stuff, and then we can ask our questions at one time. Okay, Miss Tashonda Marcelin.
Yes, good morning.
Tell us what you got to say.
Good morning. I'm sorry about all this here. I just want to say I'm sorry about having all this going on. I am dead wrong because he didn't break my phone. The phone that I'm using is the phone right now that I had, but the police seen me with two phones, so they already knew that the phone was of no value. That was an old phone I had. I was wrong, and after seeing him in jail, I really feel bad because I was wrong.
You just muted yourself.
You muted yourself. Unmute. Hit unmute.
Yes, I was wrong for calling the police on you. No, you did not hit me. I was hurt because he was leaving me. I felt like I've been with him a long time, even with the situation with his baby mother lying on him, putting him in jail, stalking me for a whole year. So I really had a whole lot of feelings going on, and I felt like I needed him the most at that time. So when he was leaving and I had to get my stuff from by his mom's house and all that, I was wrong. I called the police at a whole different area, which was in front of my grandma's house, and that is not where nothing happened at. And he actually didn't hit me. I'm down bad from playing with your life like that. I know that you don't want to talk to me no more. And my family, I'm dealing with serious consequences outside of the system for doing this because I wasn't raised like that. And, I just hope that all this could be resolved. That's why I refused the charges. Me and my dad was going to go up there and handle the situation, but I never had to go to court. I hope that my statement can't help today because he actually didn't do nothing. I was wrong, Ryan, and I apologize for that because I shouldn't have played with nobody's life like that. I just felt like I've been with him a long time. I felt like I've been through a lot with you and you was ready to give up on me with ease for me cheating on somebody. For me cheating on you for somebody, and I felt like you could have given me another chance, and that's just the honest truth. And if consequences was involved, I definitely wouldn't have wanted to go to jail from falsifying a fake report. That was so unladylike of me. I don't know where I get that from. And I know I'm not in fear of Ryan Bradstreet. Like I know his whole family know me. I'm dead wrong. And I hate to see you in jail for something you really didn't do. And for us, the black eye, I really did have a fight in front of Dollar General with a 40-year-old.
Okay, let me ask you this. Why do you tell officers the victim mentioned her boyfriend normally has a gun?
Okay, I was wrong because his baby mama said the same thing. I was trying to put him in a bad situation. I knew what I was doing. I didn't have the right intentions. And when I did that, trust me, I'm dealing with problems every day for that. I literally lost everything at this moment. Like I don't even have a job no more because my karma came back on me. I know that he didn't harm me or hurt me. And
Okay, we got that. Anybody else got any questions for
Have
me?
the police, filed charges on you for filing a police report yet?
no, but my mother said that can't happen. So I was just hoping and praying. That's why I was scared for the whole situation because I was wrong. I didn't have to do that like that at all, period.
Well, it
And
positively can happen.
yes,
A crime what you did, which you're confessing to right now.
Mhm.
You need to make sure you don't ever do that again.
I would never do that again, sir. I'm sorry about that. Like I played with someone's life, and in the midst of it, I played with my own, and that is not right. Nobody deserved this,
All right.
and I'm smart, and I know better for doing that.
Anybody has questions for her?
I have no further questions for the victim. I have no further questions.
I got a question for him.
Okay.
I see a note in your file that says this is the second arrest for domestic battery charge in 2025. And that the previous charge involved a firearm also. And that the board reprimanded you for that charge and gave you a break. Was she the same victim in that case?
No.
Another one?
That was my baby mama falsified the report on me too. She wrote a letter and let them know that I did not do none of the things that she said I did.
And Your Honor, I'm wrong because I was literally trying to be down with her and do the same thing. I didn't have the right to do that. I didn't.
Yeah. What's your baby mama's name?
Alexis Hatcher.
Hatcher?
Yes.
And that charge, she came forward and said she filed a false police report just like this?
Yeah.
And they dropped the charges on you for that one too?
Yes, sir.
All right, I don't have any more questions.
Violation number 10. Offender currently owes $662. What's your plea on that, guilty or not guilty?
I plead not guilty with a statement because at the time of me dealing with trying to get a job, I did attend the daily report center, but I had my baby mom, my baby mother, she ended up going to jail for some dealing, I don't know, but she had got danger to a child. So I had to become a full-time father. I had to go to CPS and sign papers and go to court at least once a week and take classes to get, I had my baby, I had to get the custody of my daughter, which is I let the lady make contact with my parole officer to let him know what I've been doing and why I couldn't attend the daily report center at that time being on those days.
You got in touch with your parole officer?
Since I've been incarcerated?
No, I'm saying.
Yeah, the lady, I forgot her name. The lady was, the lady talked to my parole officer and let him know and kept him updated with what was going on. But I had recently went Thursday on the 12th, March 12th, on the case over. So when I go home, I got to talk to the lady that was over the case for me to have time where it could be days where I could get my daughter and you know how we could meet and have my family members to go pick my daughter up and bring her to me. So that why like that was one of the main reasons I couldn't really get a job. But I did pay, like my family do help me with a lot of stuff because I paid $250 one time, and it's like whatever I could get and I paid. It's just that it been hard for me because I had to be a father on a newborn baby, and I'm new to this. But I've been rehabilitating myself since I've been in here. I had earned me a few certificates. I took anger management, forklifting safety class, money management. I took a CPR class. I've been in here maintaining myself, rehabilitating myself, and staying focused. So so only thing I need to do is just apply myself when I make it out there now. By the custody of my baby is safe and my family members healthy. So now all I gotta do is when I make it to society, is just get a job.
Okay. I have no more questions.
I have no more questions either. The panel ready to vote?
executive session, please.
And Tillis has moved for executive session. Do I have a second?
Yes.
Okay, we're gonna go into executive session for a few minutes. Just hang tight right there to discuss confidential matters.
Okay.
Okay. Well, we wait for executive session. Ellie, are you as fed up with this as I am? You have to laugh because otherwise you would cry. So, there's a kid with a baby mama, and he was trying to get custody of the kid because that was a better bet than leaving it with the baby mama who also has issues. He's had false police reports supposedly filed on him twice, once by baby mama and once by this lady, who used a double negative to say that is not where nothing happened, which means that's where something happened. So, using her own language, something went down. And she acknowledges that her filing a false police report was unladylike. Do you hear that, Ellie? Never file a false police report. It's very unladylike, and you are a good lady. Yes. Let me step out of character for a moment, and let me just say this, which I don't normally say, but it's probably the best way to summarize all this. Fuck me. All right. What a disaster. All right, we're a little bit in the Wayback Machine. Let's push forward so we can hear what they think. And then we'll probably call it a day. Oh, too far. All right. Should pop up here in a moment.
Okay, Mr. Bradstreet, the parole board's ready to vote. Mr. Tillis?
My vote today is gonna be, well, I want to ask one last question. Do you plan to have any relationship with either of these women?
No, sir.
Why
Not at
not?
all.
Why
Because
not?
the situation that I've been, I'm a good person and I'm very helpful and I'm willing to help everybody. But me dealing with a situation like this for the second time, knowing that I'm not that type of person, I just can't be, I cannot put myself back in a situation like this. Cause
Okay.
I gotta make better decisions in life and this one of the best decisions I gotta make. 'Cause
Okay.
I got,
Yeah, that's good. My vote is gonna be to do not revoke.
Mr. Barra?
I think what you just said is the smartest decision you've made so far. And I'm gonna, based on that, do not revoke you. And I'm also gonna make it a special condition that you have no contact with Tashonda Marceline or Alexis Hatcher. And if you do, that would be considered a parole violation and bring you right back here. Also, I'm gonna put a 10-hour per week community service work on you until you get a job. In other words, you're not gonna sit around the house and do nothing. You're gonna have to work service work or get a job. Once you get a job, the parole officer can remove the community service.
yes, sir.
Mr. Freeman?
Okay, mine could be the same. I'm gonna add one more stipend because I do not want you around either victim. You do have a child. If you got to get the child, either get an officer or get a family member, swap somewhere in public.
Yes, sir.
And I'm gonna put electronic monitoring on you for the first 90 days to make sure you don't go around these women.
Yes,
Do you
sir.
understand?
Yes, sir.
Okay, now look, it's just 2 times, and I ain't gonna lie to you, it's quite a coincidence. So I wouldn't try it for 3, but we have no evidence here to revoke you, so that's my vote today.
Thank you.
Okay, and
Okay. Do we want to take bets that this guy is going to pick up another baby mama within the next 18 months? Maybe a couple of them? And there'll be more false police reports, more issues. I don't know. All you can do is laugh. Life is just not as difficult as people make it, but good Lord, do they make it difficult. But hey, he's been set free to go make it as difficult as he wants, so be it. This seems like the logical place to leave it for today. It's a couple minutes early, but but it's probably the spot. So we'll be back tonight for Sidebar, 8 p.m. Eastern, 5 p.m. Pacific. Please do join us there. And then we'll be back here tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier if you're a channel member. Lindsay says sad. Yeah, that's probably the best way to put it, Lindsay. People out there destroying young lives because they can't take care of their own life. It's messed up. But what are we going to do? Anyways, we'll see y'all hopefully tonight here on Sidebar. Please do join us. We're really trying to grow that show, and every person that shows up, every like that we get, every comment that we receive while we're there is helpful. So hope to see you then. But if not, we'll see you in the morning. Take care. God bless. Say bye, Ellie.